You want tomorrow? Yes.
Woman 588, woman 588 by 53. Woman 588 by 23. Any information about the data, just the past. Fusing to consent to
Yes.
another patient not 3253 because of 20. This is with regard to mutation. Mutation was granted in 2009. Was set aside not 2018 on the ground that Tahsildar refused to submit the record. Therefore, I declared to pay.
Yes.
Tomorrow.
Who restrictions will execute a day? Because both the restrictions are governed by your lordship's order. It's governed by division bench order.
Which subject, madam? What is the matter?
22A.
22A.
Yes.
Which area? Ullur and Usman. Yes, tomorrow. All other mentions, because today I came late, all others excepting lunch motions and covered matters, all others give the slips. What is the 1 minute? Yes, please allow the lady lawyer. First, I request whoever, first all the ladies you mentioned, yes, please give way to the lady lawyers first. Yes, madam, please tell me. Yes, first allow the lady lawyers to mention. Am I having, madam? Am I having that subject? And exposition. Is it partner matter? Verify and come. Yes. You mentioned it many times. Why it is not coming? Yes. Please give us. What is the relief you have asked? Not to alienate. Yes, tomorrow. Others, you please give the slips. Not day after tomorrow. From tomorrow to Friday, I will distribute all the matters. All pension matters will come in motion list.
There are government total notice have been served. The properties are sought to be sold in.
Yes.
Lunch motion disposition was the district collector along with the municipality.
New matter.
New matter.
Yes, please.
Lunch motion.
Yes. Yes, Mr. Raghuram.
Taking advantage of legally entry of the current parties, the land was addressed right to eliminate the section property. Only the respondent Tahsildar. The Tahsildar is directed the petitioner without operating any action.
Why are you arguing the case? You are mentioning. You are not arguing the case.
This case is several times mentioned, but not.
Please give the slip. Not lunch motion. Tomorrow or day after tomorrow it will come up.
Tomorrow is right.
What did I tell you now? All pension matters will come in motion list only.
Compensation not paid in compensation not paid in irrigation department.
Why are you mentioning land acquisition matter?
Irrigation department.
Irrigation, yes, give it.
Page wise mentions. Page number 1.
Sir Mahmood Ali, item number 1, I request you to wait. You can send your colleague. In the course of the day, I will dictate it. It is not ready. Where, madam? Item 1, in judgment case, In 2013 matter, after 10 years, at the time of pronouncement of judgment, you file a petition.
I think last time Katkare with the Reddy represented that he has filed.
Mr. Mahmood Ali, madam, please inform your senior now. Where is your petition? Where is your petition? Your senior mentioned last week. Madam, in the petition means
It's not been appearing that there was again.
what did you do when the matter is coming for judgment? Please give copies. Give the HR number. Only then it will be adjourned. Otherwise, I have to pronounce judgment. Number?
It's not necessary.
Why it is not there in the report?
Same as Katkare with the Reddy simplification.
Petitioner's counsel is not served. Please give one copy.
This signature is there.
Madam. It seems it is served, madam. It is numbered as IA number 3 of 23, so it will come up tomorrow. If I am dismissing the IA, I will pronounce the judgment. If I am not dismissing the IA, I have to adjourn it.
Copy is not served on.
Anyhow, madam, take one more copy to serve today.
This matter, according to the interim orders, my lord, we have conducted joint inspection.
Yes,
If
you
I
told.
report also. If I report also.
Can you get it number today? It will be passed over.
Tomorrow.
Tomorrow you want?
No, I don't know.
Let it be passed over.
Do that, yes.
If I am allowing the MP, I will post it tomorrow. Otherwise, I will pronounce the issue.
Many people are alert with the same claim now. We don't know whether they are the real sister, the original owner or not.
It, I agree.
Page number 1, item 1 to 15. Page number 2, item 16 to 37.
Item number 20, yeah.
20. After tomorrow?
Council in the report is
Yes, 8 year requested.
Page number 3, item 38 to 50.
42 million. But in this matter, I'm resulting in check. For our 7 and 8. That is undergoing open access to the today post time. That's the release time. Then it's B then and check.
If he is undergoing heart surgery, only within 2 weeks, you want.
He is the only mediator to.
Why only 2 weeks? Why can't? Within 2 weeks, he will recover.
Allow Mrs. Dhananjay and
Uncle. 20.
Page number 4, item 51 to 64. Page number 5, item 65 to 75.
Item number 67, state and state not.
It doesn't reach GS 230.
number 32 and
Number
Kudus. His permission is dismissed or not.
Page number 6, item 76 to 91.
Item number 89 for all these matters was already had this matter. Matter pertains to Urban Land Seizing Act. Declared filed an application, pending application is to be third party. Third party is filed a petition. They took an objection losses with that
Yes.
230 losses.
Yes.
106 also losses both that go together.
106.
Both item 89 and 106.
The objection of GP was your vendor submitted,
Application is not entitled, yes.
you are not entitled.
My submission is not signed the steps into the issues of that person, my vendor. That's that transfer. 90. 230. Item 78.
90, I will complete the entire list. Why so many mentions?
Item 78.
I'm completing the entire list.
Item 78.
If it's not reaching, please mention.
Item 78.
70?
Item 78. Regarding survey.
My lordship permission, that straightforward coming in the court and.
We will inform after the permission is granted or.
At least I want to wait for my GP to not be there in the second. And I'm asking, what is the item, sir, who are you?
No,
I am not paying
I
it from the other
I
side.
don't know who is he.
They are taking it granted for,
You block.
You don't know who is he?
asking who are you?
I don't know, he is the
It's not fair enough on the other side.
Lord's stage. My lord's grant permission, I said, not grant
Before,
permission,
taking
we will
permission,
inform
they would have.
Forget about this. All
The open what I said, we are taking 89, he said, who are you to ask?
No,
Fair enough.
he said, Lord's, did you inform me, Lord's, that, he said, Lord's, item rating, very mentioned, yes, sir, very mentioned. Lord's, he asked me, did you inform
one
the other side?
lawyer should never complain against another lawyer. You understand one thing. If you cannot tolerate this, go and practice in Rangareddy District Court. Every day you will face 100 lawyers like that.
No, Lord's.
Cannot tolerate you. Go to Rangareddy District Court. When he practices for 6 months, when you see the litigants and lawyers there, you can face all the lawyers in India.
What he said is, Lord's, did you
Small thing.
inform the other side? I said,
Who are you? You say you are AGP. That's all. What's the big deal in that?
He is
I don't understand when you cannot face your colleague lawyer, how will you face so many challenges in life?
He's putting in.
Okay, I ask you to give explanation. I said I have seen many lawyers in Rangareddy district. I can tolerate 100 more complicated situations than this. Simple issues, don't complain and don't bring everything to the notice of court. You should understand in 1980s, in 1980s, 90s, the standard of lawyers, you know. One lawyer, whether you belong to one political party or association, you never used to argue a law case against another lawyer. Those were the standards in those days. Did any time I pass judgment in the absence of GP? How many times I have given adjournment? So why are you bothered? In the absence, I have not passed any order in the absence of a law till now in my 3 years of tenure. If they are actually this matter was heard. The only objection of GP was 455 or 747. This regularization application was filed by one person. Pending consideration, he sold it to the petitioner. Your objection is he is not the applicant, he is not entitled to be considered. Section 43 of the Transfer of Property Act, on that analogy, learned senior counsel, Mr. Mohan Reddy argued. How can you say, when I remember this, what has happened about 1 month back, being GP, how will you say you don't remember?
Okay. The person. Second after this is like.
If your GP has got any difficulty, you
Go
can.
and inform where the GP can GP after grant permission.
Why are you giving him advice? If he wants, you give. Wait. I will take up, it's a small issue if you have got it. And how many times I told you, don't depend on the GP. You should prepare. You don't want to become GP in future? You want to remain AGP permanently? When you are prepared with the case, why you want GP to come? You can go and tell your seniors that the court insisted and I have to argue. Next. 78, if it is not reaching, mention at 4 o'clock.
Number 1 item E to 173.
Which one?
Number 123 to 1. Yes, sir. Order.
Hyderabad Central University.
Yes, very first to that.
Yes, it is at 2:30. It's 2:30. Let it come.
That's a high-
Lordship's kind permission, my lord, may I make a small mention, my lord. Out of list mention, for being mentioned, my lord, WP number 26255 of 21. My lord, IA 1 of 23, this is for being mentioned. My lord,
Tomorrow.
very well, now blessed.
116 at 2:30. Today I have one.
Lordship, one repetition, 23344 of 23, your lordship.
Why this matter is not coming?
Repetition.
Tomorrow.
My lordship, my humble
My
submission.
lord.
My lordship, item number 117, my lordship, it is matter is pertaining to Senior Citizen Act, my lordship. It may be taken at 2:30, my lordship. There is urgency in the matter, my lordship.
Same number.
117, my lordship.
Which one? This Ashok Nagar matter?
No, my lordship. It is item number 117, my lordship. 117.
From the other side, 2:30.
Millard,
Obliged, my lord. Deeply obliged.
Millard, may I make a submission? Sir?
Yes.
WP number 41298 arising senior citizen matter arising out of 2007 Act, Millard. Requesting for posting, Millard. Your lordship has given 2-3 times permission, but it is not listed.
Come up. Wednesday or Thursday.
41298, Millard.
Yes, I have noted. Kindly wait.
Much obliged.
16. How many 2:30? No private respondent? Why did I adjourn this matter? The old matter. Which year? Survey, why did I adjourn it? Tomorrow. Madam, 2:30, it's very difficult. Will come up. If I once I say 2:30, always it will come at 2:30 now. I will pick up the matter. The lawyers argue among themselves. Even for listing matter, I don't understand. If such things happen in my court, what will happen somewhere else? I have to guess. You make a mention, the other side comes and objects. Then he says, no, my senior colleague is not there. I was not informed. For mentioning whether opposite counsel informed or not, you are arguing in my court. So I decided, from now onwards, I will not sit beyond 4:30. I will relax after 4:30. I will also work for limited timings. Lawyers are fighting among themselves. And you mentioned the other side counsel and comes and says, no, we were not informed. What happened 3 months back when you mentioned? What was the objection of the counsel? Again, you are doing the same thing. Tell him, if I say 2:30, then he will come with 2-3 explanations. These urban land sealing matters, the act was repealed in 2008. In 2023, I don't know. If it is petitioner and private, the opposite government respondent, there is no problem. When private respondents are there, no one is interested in arguing. And I said, in the absence of opposite counsel, I will never hear the matter. I argued that I heard the matter. Actually, I don't know how many times it will be adjourned. For whom Mr. Mahmood Ali is appearing? It is already there, 230. Once it is there, it will come up. Madam, your responsibility is to inform all the lawyers. One counsel, PV Sanjeev Rao, is no. Get all the lawyers. Why so many private lawyers? This Banjara Hills land. Why so many respondents are there? Yes, tomorrow.
Item 3, Mr. Rohit Pogla.
You, yes, you, are you?
Yes, because I am getting over the. Actually, because there is a judgment which runs into 200 pages. Otherwise, this is only 877 pages, but effectively.
So according to you, if I hold that there is no concluded contract and arbitration clause, that is agreement, not applicable, then this court will not have jurisdiction. Who will appoint institutional arbitrator?
Institution.
You go directly there.
Yes. That is the mechanism. For every institutional arbitration, parties have to go through it.
So in case institutional arbitrator is not appointed, then you can come in.
In fact, they were even in the first instance which they withdrew.
Yes, I know.
Even then, they ought at point of time they were not relying upon the amended, so-called amended article. Even then, they should have gone to the ICA. Even then, they had not gone. So the first proceeding is personally. And second, because I have placed on record one judgment.
Have you specifically taken this defense in the reply to section 21 notice? No, please, I will go through the record. Suppose they give a notice under 21 nominating an arbitrator. You respond saying that there is no concluded contract. But you do not make a claim that you are covered by
we said so
39.2 so and so, wherein institution has to be approached. If you don't take that objection, still is it necessary for them to specifically refer the matter to institution? No, suppose if you have not responded to their notice.
313. It is there.
You took a ground?
Yes. In any case, even if this plea was not taken, first of all, Milords will examine Milords' whole jurisdiction. If there is an institutional arbitration, they are supposed to go to them first. If they refuse to appoint arbitrator, only then they can come. So it is a case of inherent lack of jurisdiction. It is excluded by law. And that is what section 11.6 also. That is what judgment says. And I have also placed on record, the later judgment of Supreme Court also. It says that the agreement to, in the context of arbitration agreement and agreement to enter into what?
You are saying it is an agreement to enter into an agreement.
Okay. That's one limitation.
Both the freshman and transactions initially, but had been allowing registration to may straight away invite the last person to pay 245 onwards. 245 column 3 would state transaction Summary of statement of income reserve. 245 million. Column 3, you last missing, right? Could stay applicable transaction error. Like that, continuously, the third respondent is relevant transactions by giving some dividend. They do admit that registrations are blocked by the district collector, but by giving subdivision number, they are.
Any proceedings issued by the district collector blocking
Those proceedings are not available with me, but on these proceedings also it is clear that you last time you get continuously 246 also there are.
which court stayed? Which court has stayed?
Lower court. Lower court had subsequently, in fact, at the instance of the very same petitioner on 3 times evaluation granted interim direction, which is at page 207. But of course, only 2 survey numbers are mentioned.
Same dispute?
Same dispute, same party, same dispute. But only 2 survey numbers are mentioned. Since they are giving another survey number, the petitioner is constrained to approach this on once again. In fact, if they are not changing the survey number, the order granted by evaluation could suffice. But to avoid this, 310 order at page 207, operative portion 209.
Where is the court injunction order? Enclosed?
You last may see the last order at page 209. Start from 207 at 209. The extent is same, but at that stage we only mentioned about 2 survey numbers. Since we have come to know about the entering into transactions by giving the subdivision numbers, we are constrained to approach once again. But for that, only difference is we have mentioned all the subdivision numbers now. We are not aware of all those.
Under circumstances order dated.
Item 4, Mr. Ravi Kumar Reddy.
Number 11. Application of earlier in 2019 also the issue proceedings. 14 for 2019. Then my name is Ravi.
Where is your application? Why are you not mentioning that in the prayer? Why don't you mention Dharani application number in the prayer? Final prayer, it is not required.
I'm sorry, because
Petition is. Date is not there.
Is there, the rule is regular. Particular, equal.
Said to have been.
Item 5, Mr. Ravindra Reddy.
An application.
Papers it is 14. Why can't you come after 45 days? Why there is so much haste? Why everyone comes within 1 month? 45 days lapsed?
8 September.
Which one? What does that mean? This is 28th September. 45 working days are over. So you will have Dasara vacation. The MRO RDO should not have Dasara vacation. If within 1.5 months, if people are coming here, what should happen to the poor people who cannot afford to file a writ petition? Your cases will be taken up, their cases will be kept in. These revenue officials are directing them to file writ petitions. If this happens, there will be a lot of injustice to the poor people. What is the use of digitizing the system? And again, compelling them to come to the court. Why there should be digitization? Then go back to the manual system. That is better. Petition is going to declare
Item 6, Mr. Rahul Bhaskar.
Seven,
11, 9.
11, 9. Why are you not giving them time during election period? From now onwards, I'll do one thing. When will the election results be declared? So I'll give 2 months time. I'll give. For 1 month, I'll say till November 30th, I'll say 2 months instead of 45 days. Better
3 months.
3 months. Huh? 1 month is enough. From 1st December to 31st December, it is enough. Actually, they are the nodal officers, yes. Revenue office, MRO, RDO. They will be busy. Go and request the election commissioner to suspend all the revenue proceedings for 1 month because you don't have officers to support the election process. Then you can also relax for 1 month until elections. This petition is
Please. When the information is fed, I will for the order pass by respondent number. If that is not has passed my document, I think that previously lodged is passed, not that to disperse the representation in regards to the one process. But lodged will kindly see page number 40 and the peaceful owner and the person of the land, situated in Momin Kalan to an extent of 7 acres.
There is no option in the module to incorporate survey numbers online soon after this.
Upon such an action, we have filed with the
Today, why? What is the endorsement you are challenging?
Page 27.
Page?
Now, after filing two petitions, now they are coming forward and stating that said I want to proceeding the cancelled. No chances given to us, the lordship in the cancellation is not communicated to us. Page 27.
Let's ask. Let it be decided whether it is a government land or not. There is no point in passing order. Now, this is the third time you are coming to the court. Respondent shall file counter by receipt of the court to.
Petition is 74 years.
What stay? They are saying it is a Sarkari land.
What will of the land? When Pahani and come and show his name with the previous owner's name.
Do you have any apprehension that you will be dispossessed? Why there should be stay when third party is not involved? It is between you and government.
They are acting against the petition.
Status quo obtaining all and today shall be maintained in respect of land adjoining 7 acres 16 meters in S number zones.
Let not follow due process.
Hotel,
No. The co-working space.
co-working space.
Yes, sir. It's a hospitality service, but there is co-working space.
Hospitality. So co-working space also is called hospitality.
And under there.
I thought only catering and service something to do with the food.
Yes, sir. But absolutely, but it's the co-working space.
Co-working space.
It's not approved. This owner has not approved. He is approving this. Nothing that not been done.
Let them issue notice, sir. That is only sufficient. Due process also may be.
Where is your list of sale lead?
Sale lead is on page number 2. Sale leads are there. One on page 21. One more on page 29. 2 plots, sir. 300 square yards and 300 square yards. 100 square yards.
Amar Agarwal Cooperative Housing Society. Itala Begum.
Yes, sir.
When was it?
2005.
2005. I think only objection should be of not urban land ceiling. The scheduled property is not assigned as per urban land ceiling act. Assignment is different, urban land ceiling is different. The person who has registered, sub-register, he should be given an award. He is saying it is not assigned under urban land ceiling act. Assigned. Since he has sale deed from 2005, it is retail. The petitioner is a tenant, landlord sale deed is fine. Section GPC study legislation.
So, Apple basket.
No part.
Applying passbook. At least your father or grandfather, someone's name should be there. So your vendor,
Not applied for passport.
either passbook or one Dharni entry for the last 5 years, whether your vendor or vendor's vendor, someone's name should be there. Find out PPC certificate instruction 14 motions.
Item 10, Mr. Rapport basket.
Why will revenue officials interfere in agricultural lands?
Phone number, the director, the center of Bharat, one, but in, is in, here the, assigned to the, finish the.
Where is your passbook?
He has applied for passport. Then recently he has applied for passport. The allegation is that not the unofficial response are asking them not to use their own money. Sixth respondent. In the allegation also it is stated.
Notice to respondent number 6.
This application, my lord, it's of 2022. My lord, I'm seeking only for disposal, my lord. 22/2, 2022, my lord. It's at page number 13, my lord.
TP assignment. The petition is filed.
obliged.
Item 12, the card on the following.
Order number 4 and 3 and 4. Let's take the order stated, order proceeding stated, 39/2020. So these are the.
Chicken center. Chicken center. Why have police taken? You are running business. Why did the police enter into the picture?
That's not. They have come into.
I can understand a vacant plot. Why police are interfering in business establishment?
This fact was this.
I hereby issue 145 CRPC proceedings for seizing business shop and business office of Moon Poultry Point, Moon Chicken Center, so on. So who is the opposite party?
9 is the what the proceedings do not based on the 29/9.
Who is the opposite party?
Opposite party.
Why have you not made him respondent? You are tenant, eh? Why have you not made owner party? And tenant landlord dispute results in 145 proceedings.
Petition filed already. Intention is there against them not to.
So, madam, police have started deciding tenant landlord dispute from now onwards.
Instead of that intention on the.
So what?
Page number 19, relevant page number. Page number 18, in view of the.
Tenant is indulging. If a tenant is so cantankerous, filing 7 cases against landlord.
Not landlord, against the tenant.
Tenant is the accused and landlord is the complainant.
Yes, they are filed. Originally, two brothers.
Who is the complainant in these 7 cases?
The litigation is between the brothers, my lord. I am the tenant. Page number 18, my lord. Last para.
Why are you coming after 1 month?
Already given representation.
Seized property?
Yes, my lord. They have released it. Subsequently, again, contrary to their own proceedings, they have again passed other proceedings on 13/9. On 13/6/23, they have
Why are you not making other persons respondent? They are necessary parties.
because of the revenue.
This is a dispute initiated at the instance of landlord and his brother. They are necessary parties.
One order is being passed on 13/6/23, releasing my property, and again contrary to the same.
Make them party. I would have granted interim order.
Because there is a contempt petition pending before the Honorable Court, they have seized the property.
I would have granted interim order if they were made party.
But I make them party in a well.
How can I grant?
Let them indicate the parties, your lord, so I'll get instructions.
Petitioner is directed to. File rest petition without including them.
Because the order passed the new department.
In 145 proceedings, are there 2 parties involved or not? 2 or more than 2? Why have you filed only against RDO and executive magistrate and not against private parties?
Because once the order is being passed.
So what? So will they continue to have interest in the property, or they will their interest will be extinguished?
Item 13, Mr. Pramod.
Action response trying to say not to good. Read facts in the field. Even Ramesh Dubey was the owner of, and he sold the property to different people. He said 2 were registered, 1 was unregistered.
Thereafter, these three people have sold many times. Finally, the petitioners have purchased the property in the year 1999. In between, all of the registered sales from 1983 onwards. Only one of them was the unregistered sale. It was regularized, then 13P vacancy was also issued. After 20 years, the daughter of the postal vendor files an application that it could not have been regularized under 5 years because an agreement of it, not a sale. But that went against us. Rich petition was also filed. Rich petition also went against us. Not us, but my vendor, against us. Order copies had to be received. In between, there are so many sales. For last 24 years, I have said 99 sales. Prior to that, my vendor had a registered sale. We are in position. So taking advantage of the order and the name being written in the they want to alienate the property. Now, because of us, I have already to protect my property, but I have already filed a civil suit subsequent to the petition order. Then I have a status court. In spite of that, your lordship may come to publication. Cause of action is. Your lordship may come to page number 224. A public notice is given whereby this daughter, through her AGP holders, is trying to alienate the property, taking advantage of a name being reflected. But I gave a reply to the advocate saying that this is what is. I have a registered statement on the owner and a further property just because the entry revenue interest does not do anything. And the regulation is of the 1983 method. So therefore, I have a right for the property. Your lordship may also come to the suit method. That's page number 222 order. I filed a suit because we are trying to interfere. I filed a suit. I have an interim order of status quo. On the first senior citizen.
Automatically it will be blocked there.
No, it's not necessarily a good thing because I have to take my remedy. I'll work on a remedy for recovery. That's different issue. Pending this, they're still taking advantage and trying to alienate a problem. And I have given a reputation. No action will be taken on that.
Petition filed for.
But I have to take it because originally 5 years to regularize. Then after 20 years, the daughter of the original vendor files an application saying that the agreement of sale could not have been regularized. Form and running the statement. That was upheld. Then I went filed a rich petition. Rich petition also has been discussed. And order copy is to be received by me. I have to work out a writ of payment, whatever. I can. But admittedly, I am a registered owner of the property, person of the property from the year 1999. Prior to that, from 1983 onwards, my vendors are there. For the last 45 years,
the status quo is only with regard to interference, not for alienation.
I could not have done this, not for alienation. On that day, there is threat of interference. So therefore, I filed a suit. I did not seek a declaration suit because I have registered status from 1999. Now, taking advantage of only the interest.
You did not get the order copy till now?
No. 1999 is the order. And I could not have filed a writ appeal without including order. So, taking advantage of the increase in Dharni portal, Dharni portal is still a revenue entry. Revenue entries will not have a right. They are aware that our registered sales is from the year 1999. Prior to this, my vendors from 1983. It's 40 years since we have the title and position.
Respondents to
But even assuming that 5 years is not valid, I have asserted my right as the owner, possessor to the open knowledge.
take short notice. I will hear.
We will say the entire data complaint to them. Your lordship
can be reversed.
No, but your lordship would only say, consider the reputation. If you get it on the bar, it's not possible, let them not do it.
The respondent.
Damodar Reddy. Write the appeal before the regarding pertaining to the directive issued by the Indian Ministry that I write the appeal before the RTO. Along with the state, now state petition is not being considered by the RTO, that's why I am looking for the conclusion. Let the brief as far as
That lot of knowledge is stated only.
directed me
No,
to
our
find
point
the
is not now this appeal cannot be considered.
ROR,
But he said that appeal is filed, no, that-
along with the state petition I filed.
that's not five by. Appeal, no, that. In the appeal, no, that.
Page number 38 is the R pass verification. Immediately state that in case such an appeal is filed along with the application for stay, the appellate authority after affording an apartment.
where is the order in writ appeal, which page?
Page number 38 in page number 36. is here. The operative portion, page number 38. Decree for correction of the entry unit was obtained in the year 1972. It was implemented by the Legislature in 2009.
Yes, they were given liberty to file statutory appeal.
Still along with the state petition. Now I filed the state petition that, and the RDO also given number, that the appeal number also for this, that C/35554 of 22. Same petition is not being considered by the, that's why. Item 15, Mr. No.4, right.
The appeal was filed before the state court of the Agency Act, section 90 of the Act. On the filing of the appeal matter, I filed a petition for interim direction. Thereafter, I filed an IA matter, which is annexed at page 21. Praying for not to make any changes, not to make any to protect the land. This has been
Can tenancy court or appellate court grant such orders?
because they were laying layout. Not my plea before the lordship is because I had asked it. I had requested district. I was crying horse. Please give some orders to protect the land because they have now lordship has seen photos.
It's not even 2 weeks.
No, 2010, 22, 1 year back.
22.
Yeah, lordship. And lordship has seen.
It is submitted by
Page number 2, item 16. Visitor. Okay.
Implement orders of this court. Pass over.
Something there is challenge that referring to their price, 6623.
No representation. Pass over.
Item 17, Mr. Ravindra Reddy.
An application. 29. Petition another. Number 40.
Dated
29, 2023. Page number 14 on the version, the application. 52, 2018.
latest application is the 209. Claims to be absolute government.
Item 18, Mr. Chakravarti.
Petition is filed against the orders of the special judge without giving the notice to the petitioners. Before passing of the interim orders passed by in the petition.
Interim orders.
Interim orders passed in WP till 20 of 2021. That the tribunal disposed of all the matters without issuing notice to the petitioners.
Before passing order in pill. The general order, why have you not filed application along with the pill order?
That was not filed. Yes, it was not communicated.
Now you file, automatically it has to be reviewed, there is no time limit prescribed by the division bench. You file, if you had filed, I would have granted interim order. You did not approach.
Not approach this.
With the order copy in pill, you could have filed application, what we did, we say recall, file an application for recall.
Yes, now they are not taking the application.
Why will they not take? You give me inward number.
Another petition before this area. Find the order copy of the same. Page number 36. And 38.
For the same relief, you filed another writ petition.
38. Not for the same. Earlier also,
So,
the orders has been passed by some court to make an application.
why have you not made application?
And as I have not made an application and they are not taking, they approached us before the Sound Court and filed this writ petition at page number 38. And a direction was given by the Sound Court to make an application.
Why have you not made then? Even
And-
today you
and
can
not-
submit it.
You are liberty to make an application. Post of, even a. And liberty to make an application. I think that's-
No. Parties are same,
No, parties are not
different.
different.
You did not file writ petition.
I am not right.
Similar case you are referring.
In that case, I have. For the
Automatically.
sake of this on code, I find the judgment copy before this one. To show that in another case, there are another case not.
We'll do one thing. Let the respondents come. I'll grant interim order. GP, there is a general order passed by division bench. He is saying he is having difficulty now in going before the authority for review of the order. Why will they do that? Because of 2 years gap.
On these matters, what happened, special tribunals were constituted only for the pending cases.
Pending cases.
Thereafter, they are not at all entertaining any merit posting. That's why
There
they
are
are disposing all the matters.
Still, we have issued this on.
So this order is passed by the special tribunal.
Pending cases. But if it is before the division bench's order, even then.
Before division bench. What is the order date of division bench? No, this is after division bench, no? No, before.
Before. The challenge before it's not.
Where is the proof that you have approached?
Number of cases we are challenged. Because under section 16, council, the special tribunals are constituted, and after hearing the appeals and divisions transferred thereof.
It is patented by Leonard County.
With regard to those properties.
Covered by proceeding.
Mr. Rapol Bhaskar.
Much more.
Item 20, Mr. Rahul Bas.
At least or more than 95% you have pata.
21, Mr. Rahul Bas.
Today, you have all missing cases only. Same, huh? They are brothers. Huh? All cousins have missing extents. Huh? Actually, when large extents are there, 20 acres, 10 acres, people are not bothered about the missing of 5 guntas. Now, when the extents become small and values increase, these people now, in the beginning, it will be the same. Huge extents and when the value is less, no one is bothered. The land is not there, from where will you trace out? The boundary dispute. Villagers never objected. Suppose there is a lake, they wanted to construct a pond during some floods. Slowly, what they do on that day or during that time, no one will have imagination. So for pond strengthening, if they have to take land in that alignment, I am assuming, I am giving you example. You will not bother because on that particular day you want to protect your land. So everyone will voluntarily offer. Their lands will be taken to some extent. Likewise, if road was 20 feet in the village, it is expanded to 30 feet, you will feel you will be benefited. You will voluntarily surrender. That benefit after 20 years you will forget. Now you say you have shortage. Actually, they did a good thing by introducing that LRUP program because you know at least what is the actual extent.
Twenty-two, Mr. K. Venumadhav.
What is now going to intended to
Vaikunta Dhamam.
here when there is here an application submitted by the petitioner, survey was conducted, notice was fixed. But the very same respondent authority. Even after that, now again they are coming. Why it was done?
Mr. Ramon Reddy and AGP Revenue try to protect people who are alive, not the people who are dead. First, give importance to people who are alive. Your policy of establishing Vaikunta Dhamam in every village is a good thing, but why do you interfere in private properties?
The government and the revenue department allotted land in survey numbers for 960, 968 and 969. Now, as we start the construction,
Petitioner, because he has Pata passbook, I will grant interim.
Item 24, Shivchandra.
Line.
Patient is having the ask by private response is there, it does not have line change.
No private respondent. Date 19/9. Again. According to the AGP, the revenue officials are busy in election duty.
The Bhaskar Reddy, item 25.
Senior citizens.
Not numbering the opinion from the.
They should be given direction. That's orders in upper. Now again, district collector, it is Senior Citizens Act. So according to you, during election duty, you don't want to entertain senior citizens case also? I'll say 4 weeks thereafter.
Not matter from the senior citizen act.
Let him pass order, he has filed appeal, he may mold the relief.
Yes.
He may not pass or he may mold the relief. He may send them to mediation. Father, sons. 412.
Item 26, JV Ram.
There at page 20, 9/9/20. Petitioner's father had 20 acres of land. Now suddenly Madam that petitioner is only 4 acres of land, not 20. And with regard to other persons who are related, those people's names are on there, 16 and 18.
Private respondents are there. I will pass interim order if you want.
Yes.
Better, so many private respondents are there.
The interim order. Which powers are submitting. There's a order of your lordship, which is that.
I
father, they have got the land from that announcement father.
If family members file partition suit,
Yes.
I may have to modify this order. 412,
So that. Personal notice.
yes.
Item 27, distribution drafts.
Same property,
Survey number 6/6
petitioner, you should plead that. This judge said this.
Item 28, Ms. Ravalik.
I made online application in the last year, Your Worship. The application was pending lately. Requesting the respondent authorities to correct their errors.
State letter, Now, because of elections, they are requesting for more time. Instead of 45 days, I am saying 2 months.
Item 29, Mr. Deepak Misra.
Standing counsel for
Petitioner sought information under RTIS. Page number 13. That what the Usman University does is it powers to some department. The department replaces to 15 year student.
you are a student. He is the same student who came before me and said he was caught in, he was not allowed to write an exam because there was an allegation when he went to the washroom, he went with one book.
He is not that. He is not that student.
Why are you why you want this information?
This information pertains to
Continuously, I don't know, same person, not the same
Not the
person.
same. Is why he needs this information is because for the academic year 2 years back, the attendance there was an issue regarding the attendance.
So,
There was an issue regarding the attendance. His case was that biometrics are not working in the college because there is mandate and directions by the Usmania University to have biometrics on the class. Ultimately, he approached this honorable.
kindly furnish university circulars also soon.
Yes, all circular.
Expenditure made since last 5 academic year for biometric. Why students are indulging in this type of litigation? If you have shortage of attendance, go and request the authorities to exempt. Why are you harassing the college management?
Expedition was allowed. Pending the fraud that the attendance was not properly counted. And the issue of biometric was also there. Interview was awards were passed in. But very next year was again the same issue cropped up. That is the reason I have to see. Now he is continuously writing in final year last student. Rashid knows now.
Yes, I think same college. He's no, he was in ERR college. Center was Petacanty College. I think he went to the washroom 2-3 times. You can understand what happened. He was caught. He says there was nothing on my table, on my bench. He was asked to go out of the examination hall. He comes here and argues this case. Almost he appeared in my case court more than 10 times. I told him, instead of wasting time here, why can't you prepare for the exams?
He is not that.
I said, are you detained in that year? He said, no, I am not detained. I can write exam. Even if I allow the writ petition, I cannot direct exams to be conducted for single person. And his answer was, sir, this injustice should not be done for others.
Who are the others who were there?
See, I don't think the invigilators will have prejudice towards students. Something happened. Then he wanted CCTV cameras to be produced in the court. He wanted inquiry to be conducted. What will be the inquiry?
He is not that. He is a student of Petacanty College.
Attendance.
Same, you also, because of attendance, you are targeting them.
But at exams, he has written yes.
Why you are concerned about expenditure spent for this biometric?
For enthusiastic must.
In another case, the person who came to this court, his son was in 4th class. During COVID, he wanted some exemption, something happened. Government issued GO 25 saying that excepting tuition fees, no other fees shall be collected. 50%. It constituted 50%. He asked for exemption. They gave him 2 or 3 installment facility. He could not pay. Then court said we will not extend online classes to your son. You know what he did? He filed RT application for not for 4 or 5 years when his son studied. For last 10 years. Why is he concerned? He is saying, no, I want information. What is the connection between him and that school his son is studying? Only for the period when his son is studying, he could have asked for information. He is saying he wants information for our last 10 years.
How is the position of school? Your lordship knows the very good.
Unfortunately, there is no provision. That one provision about confidentiality is section 8. G, I think, and another section 8E. 8E. Right to Information Act. So a person who does not have any interest here, it is not like a government tender. Irrigation project is there. You want information about expenditure, I can understand. When your son is studying in school since 4 or 5 years, you want information about 10 years.
You see, and lordship. 10 percent from the lordship. There was a parent with me at 84. Requesting me a favor that as an alumni or as an advocate of the court, because you see, class percent, 8th class. Spoken to brother, found that the student is carrying hookah to this class. I said, I can't. Very same issue what your lordship just asked for, asked for. I told the parent to go to the lecture. He is CCTV, set up, then come back. But Brother said me clearly, that we are not personal prejudice against students. We want other students to give.
Item 30, Mr. Ajay Kumar.
You want me to pass it over or will you inform the other side?
I don't pass to all the.
You are saying it is exempted.
Yes, Your Lordship, under GOL for 667 as well as the 81I, Your Lordship. Because in some cases, special officers are exempted from.
What
this.
information you wanted?
Case is about the matrimonial case, Your Lordship, before the 3rd Metropolitan Court, Your Lordship. They are asking for the salary slip of my lord, page number 7 of my instructions, Your Lordship. What
As per judgment of Supreme Court in Rajneesh versus Neha, he has to disclose. Why he want this information? Not here, madam. In the family court, he has to disclose. Husband, he will get that information. Court will send.
Yes, if the court asks, we can provide all these things.
I
but
filed MC number 32 of 2020. I submitted at the time of hearing intelligence case. Judge asked me to produce service details. How can judge ask? Judge is bound as per order of Supreme Court.
Yes, Your Lordship.
Husband and wife have to file their statements, income statements. Supreme Court said that judgment is applicable even to the pending cases.
And she was asking for the.
Why will the family court ask her to produce?
allowances information, deduction information, everything she is asking, your lordship, as well as name of the family members.
Instead of going to RTI,
They can go.
PIU, they can ask, they can file 151 petition, the family court will direct the officer to file. Waste of time.
And we have given the reply also, your lordship, to them. On page number 5.
APSP comes in intelligence police,
Yes, your lordship, it's actually
intelligence and security organization.
reserve inspector of
Also.
Item 31, chocolate dip.
Petition. More was granted over the years. There was several surveys can be.
First survey was conducted, second survey was conducted. Subsequently, also the no survey report was filed. Subsequently, as per the instructions of the RDO, as a survey was that my request is that no subsequently the lordship classification also was submitted. Meanwhile, the FIL for recovery and declaration investment property. Two survey reports are not submitted. It is for interest of a particular. The state suit particulation. I am also filed a suit for injunction in respect of my property. We are claiming one survey, they are claiming one property. My property is conducted model to layout by obtaining the layout. Different human respondents are included in this case. Mine is different survey number, there is so burden is on them to establish. So let the survey may be conducted or let them be established in their case. We have suit particular survey. After your lordship's past an order. When the order was produced for the concerned authorities, the only order
Yes, said some words also in the. There has been a contempt also filed. That's pending. With respect to the survey. With respect to the previous survey before the past sort of purpose. I have a survey in here to go. Subsequently, in 2023, 3 different surveys were conducted. Last occasion, the revenue department has given an instruction. Now they are writing a different story saying that this is an assigned property of government. So the different stories have been given.
Survey is conducted.
After your lordship passed an order copy was given to him, then survey was conducted, but no copy was given to us again, yet again.
GP, they are saying survey was conducted.
They say, in the very same was not publication, they say, it's an assigned land in the government lands. Whereas it's both private parties are conducting, that's different hanging. Our third hanging is being given by the parties, by the government. They're saying it's an assigned land in the government. That's, I think we both can agree to one point that it's not an assigned land of the government. I find a contempt notice for contempt case. The courts will take a plea. Whether the joint survey was conducted or finalized or not, since it was addressed to the AD on 19/4/2023 by the RDO.
Want to get instructions. Let him get instructions.
One 32, the B Balaji.
Third, whenever you have number of items here, why can't you mark it? Which one is yours? How will I know? There are 31710. Delivered? Delivered number one? Item on hold, door locked, intimation, sir. If it is door locked, how did he serve? Why do you send on your own WhatsApp message without code? Did I permit you? So on your own you will send it. Then why do you want an order of the court? You do it on your own. Why are you coming to the court? If you are doing it, service of notice will be only after court permits you.
Page number 13.
There shall be interim note. The representative. Let it come on 1812. If that person is posing application, he will come.
Item 33, went the family. This was issued in case. 148.
Madam, you filed writ appeal?
The order was passed, which is to go to the.
Did you file writ appeal?
And saying we had the
Consequential bill.
it was not mentioned in the order.
You did not file writ appeal, madam? It's more than 1 year. Madam, it's 1 year. Content TSHC.
Not be allowed, because surgery also.
The request of learned AG. Education department has got to do with elections. They are also in election duty. So why can't all of you take off and I will also take off until elections? You don't want me to pass any orders?
There are complaints there.
So 4 weeks for complaints, otherwise personal appeal. 4 to 8. 2 to 4.
Item 34, 35. So Balmohan Reddy.
He wanted to appear in conflict.
Other side. Where is she?
Yes, right, one kind of but he said, we have letter of information. First case, because the complaint of right about second case, because the order of special tribunal was challenged, is without notice and covered by your lordship.
Party. Sunita, wife of Vasudan Reddy.
Last
Meera. మీ పేరేంటి? మీ పేరు సునీత.
She came under.
రాయని పెట్టుకోవచ్చు కదండి. ఇద్దరు లాయర్ కలిసిపోయినట్టు ఎట్లా మరి మీరు ప్లీజ్
He's a lawyer.
1 minute. He does not want to engage a lawyer. సరే మీరు ధైర్యంగా కొట్లాడుతున్నారు కదా మళ్ళీ ఎందుకు ఏడుస్తున్నారు? కొట్లాడండి మీరు. ఎందుకు వచ్చినప్పుడు ఎందుకు ఏడవాలి? ఎందుకు ఈ సొంతంగానే కొట్లాడుతున్నారు కదా కొట్లాడండి. కరెక్ట్ రెస్పాండెంట్ అమ్మా కరెక్టే. మీరు వచ్చినప్పుడు ఎందుకు ఏడవడం ఎందుకు అంటున్నా? ధైర్యంగా కొట్లాడుతున్నారు కొట్లాడండి. Why are you troubling this lady? You means your client. 1 minute. Deepu is Jaychandra Reddy game is big related. Uttam atanu. Jaychandra Reddy ki మీకు ఏం అబ్ది భర్త చనిపోయిందా? నేను అడిగినా దానికి చెప్పండి అంతే. This 302 case was registered. How did your father acquire property? Father,
Page number 15. Paragraph number 4, we got given the details of sale deed, what father has purchased, what I have purchased. Paragraph number 4, we got
page
52. Paragraph number 4, we got given the details of sale deed. The father purchased, what I have purchased.
what was the occupation of this person?
Absolutely in the speech. But paragraph number 19, page number 53, paragraph number 6 has given details of ancestral property also. The RDO says half shares to be given to her. They have purchased through sale deed. My father has gifted because of some, there are issues in the family, I don't want to get into it. RDO directly partitions the property. Not page number 53, last paragraph. I read the order. What arguments can be conducted of? Verified material as for particular original concern minority both are visible title on half share each on every land. Person of Pateda, Mansoor Reddy, who is the husband of petitioner, who expired after his divine in the land changed the name of second son. Instead of half share, he started talking about as per verification of revenue report. This so and so was Pateda of land hearing the number so and so, Martul village.
Let the Tehsildar conduct no inquiry. You challenge that order.
Lord, this order I challenged in a special tribunal, that is at page number 49.
Dismissed you.
The special tribunal without protest directly passed the order, no reasons to interfere.
Let the Tehsildar conduct inquiry now.
Lord, this special tribunal order, Lord, is without any notice covered by your lordship's orders.
Then you filed another petition. You filed another petition for reopening.
No, Lord. 35 in the challenging, 34, Lord. Pursuant to this order, I came before this court and this court passed order, Lord. But your lordship will get a.
What is the order which you have challenged here?
Lord, 34 Lord, stoppage of Praitubal. 35 Lord, challenging the order of special tribunal. Lord, 34 is consequential to 34 Lord. 35 fine.
What was her husband doing? ఈ భర్త చనిపోయిన ఎప్పుడు ఏం చేస్తుండే అతను ఉన్నప్పుడు ఏం పని చేసేది ఇదే భూమి వ్యవసాయం చేసింది ఊర్లో తండ్రి ఎప్పుడు చనిపోయింది మామ గారు ఇంకా పెట్టుకున్నారా ఆయన ఏ ఊర్లో ఉంటాడు మీ ఇల్లు ఇప్పుడు ఎక్కడ ఉంది వాళ్ళు ఏమంటున్నారంటే 74 సంవత్సరంలో మీ మామ టీచర్ ఉద్యోగం చేసి ఇప్పుడు కూడా టీచర్ ఉద్యోగం చేస్తే అతనికి జీతం వచ్చింది దాంట్లో ఆ డబ్బుతోని ఇది కొన్నాడు అతని సొంతం ఆస్తి జాయింట్ పెద్దల ఆస్తి కాదని అంటున్నారు అది వాళ్ళ కేసు మీరేమంటున్నారంటే మరి అసలు మీరు అంటున్నారు పార్టీషన్ సూట్ అన్నీ వేసుకోవాలి మరి From where did she get this?
Filed one DVC that is pending against father-in-law and brother-in-law and his son.
Why do you trouble this lady? Actually, family, your clients are here in the court. Forget about it. Today, father-in-law is alive. మీ ప్రకారం వెయిట్ మీ ప్రకారం మొత్తం ఎంత ఉంది మొత్తం ఎన్ని ఎకరాలు 35 మీ ప్రకారం మీకు ఎంత వస్తుంది అనుకుంటున్నారు ఎట్లా వస్తుంది 35 ఎకరాలు కదా మీకు 17 ఎట్లా వస్తుంది మీ మామగారు ఇంకా బ్రతుకున్నప్పుడు మీకు ఎట్లా వస్తుంది 15 నేను మీ 35 ఎకరాలు ఉంటే మీకు సగం భాగం వస్తుందా 3 భాగాలలో ఒక భాగం వస్తుందా నేను ఒకటి అడుగుతుంటే దానికి జవాబు ఇస్తారా 35 ఎకరాలలో మీకు 3 భాగాలు చేయాలన్నా 2 భాగాలు చేయాలన్నా 2 మరి మీ మామ ఎక్కడ పోతాడు మీ మామకి ఏమొస్తుంది ఆయన బ్రతుకున్నాడు కదా పెన్షన్ వస్తుంది 3 తండ్రి 2 కొడుకులు కొడుకు చనిపోయింది ఆ కొడుకు భార్య మీరు మీ భర్త ఈ రోజు బ్రతికుంటే 3 భాగాలు వస్తాయా 2 భాగాలు వస్తాయా మీరు చెప్పండి అమ్మా 2 భాగాలంటే మీ ఒకటేమో ఇతను మీ మర్ది ఇంకోతనే మీ మామ మీ ఎవరిని తీసేసి పడేస్తున్నారు మరి ఎవరు పనికిరారంటున్నారు మీ మామకి ఇవ్వద్దా మీ మర్దికి ఇవ్వద్దా ముగ్గురికి ఇవ్వాలనా లేదా సరే మీరు ఒక ఊర్లో పెద్ద మనిషి ఉంటే తండ్రి 2 కొడుకులు మీ దగ్గరకు వస్తే 3 వస్తే 2 వాటాలు ఇస్తారా 3 వాటాలు ఇస్తారా మీరు ఎట్లా పంచుతారు నేను ఒకటి అడుగుతున్నా చెప్పండి మీ దగ్గరికి ఒకరు వచ్చినానికి 35 ఎకరాలు ఉంది తండ్రి 2 కొడుకులు ఉంటే మీరు ఎట్లా పంచుతారు దాన్ని మీరేం చెప్తే అదే ఇస్తా మీకు కూడా జడ్జిమెంట్ చెప్పండి నేను ఒకటి అడుగుతున్నా చెప్పండి మీరు 3 వాటాలు ఇస్తారా 2 వాటాలు ఇస్తారా అవునా ఎవరిని తీసేస్తారు ఇద్దరి మరి తండ్రి 2 కొడుకులు ఉంటే ఎవరికి వాటా ఇవ్వరు ఆయన తప్పు చేస్తే నువ్వు కూడా తప్పు చేస్తావా కబ్జా పక్కన పెట్టండి కబ్జా గురించి నేను మాట్లాడడం లేదు భర్త చనిపోయినందుకు ఆ వాటా మీకు వస్తుంది ఈరోజు భర్త ఉన్నాడని మనం అనుకుందాం తండ్రి 2 కొడుకులు 74లో తండ్రి కొనుక్కున్నాడు పెద్దలు ఆస్తని మీరు అంటున్నారు అనుకుందాం పెద్దలు ఆస్తని పెద్దలు ఆస్తుంటే తండ్రికి ఎందుకు రాదు తండ్రిని ఈరోజు బ్రతుకున్నాడు కదా తండ్రి బ్రతికుండకపోతే మీరు చెప్పింది కరెక్ట్ సగం బ్రతుకున్నాడు కదా ఆయుష్ ఎక్కువ ఉంది ఆయన రాసి పెట్టింది సరే అమ్మా ఈరోజు 3 వాటాలు రావాలన్నా 2 వాటాలు రావాలన్నా పిలిచి వస్తలేరని నేను పిలుస్తా దీన్ని అడుగుతున్నా మీ మైండ్ లో మీరు ఒకటి కాదు వాళ్ళు అన్యాయం చేసిండ్రు మా భర్త చనిపోయిండు నాకు 2 అంటే 35 ఎకరాలలో సగం మీకే వస్తే మరి మిగతా వాళ్ళకి ఇంకొక అతనికి ఎట్లా పోతుంది మరి ఎట్లా పంచుకుంటారు భర్త మీరు ఒప్పుకోకున్నా 3 వాటాలు వస్తాయి మీరు ఒప్పుకోకుండా సరే అది ఆ సమస్య నా దగ్గర లేదు పార్టీషన్ సూట్ లో తేలుతుంది అది అని మీరు ఇట్లా మాట్లాడితే ఎట్లా మీ దగ్గరకు ఎవరైనా వస్తే మీరు ఎంత ఇస్తారు ఎట్లా పంచుతారు మీరు yes this lady is saying she will agree what I got from my father. You ask your clients to come why do you trouble this lady first of all I am telling you I cannot provoke this lady understand one thing no lawyer might have raised this point in a partition suit even if father has purchased son that is the reason first question I have asked whether your husband cultivated the land she said yes so he was taking care of father's property it has to be treated as a hotspot and it's a joint family property prima facie I will record that I am not concerned settle the dispute don't trouble these people
Lord, that if these parties come, Lord, the actual truth will come. Lord, also, that
After death of husband, who will maintain?
not getting into other details.
I am asking you, I have to enter into the details.
She has her own property.
Why?
What my father gave me is 11 acres only.
Read section 26 of the DVC Act. Any court can take cognizance. I will tell you, I will show you the provision.
And all my clients also, your lordship.
Whether you call or not, first you have to make efforts to settle it. If not, I will invoke that provision and I'll see who will give maintenance in on the death of her husband. She has a shared household. She will have right of maintenance over estate of husband. So estate of husband we will assume today. You have not filed any partition suit. Husband, according to her, husband was cultivating land until his lifetime. He died because of cancer or some other reason. So her right will continue. I will say status quo to be maintained. Partition suit has to be filed.
Father gave his will by way of gift for 80 and 90. That he has given to because of his own reason.
What are the other ancestral properties acquired by him?
Not other ancestral properties also given the details before the RTO itself.
How much? 25 acres.
That is
24. 35 minus 11.
no. That is about 15 acres.
When was the gift deed executed?
Not in 2014.
14. Date of death of his elder son. భర్త చనిపోయినప్పుడు గిఫ్ట్ డీడ్ మీ భర్త చనిపోయిన తర్వాత చేసినారా? How can injustice to be done to her just because she filed criminal case?
No, Lord, this is after this. After this,
Gift deed was prior to death or after death? Naturally after death.
I don't know the details. But given the details of ancestral property and given the details what I have purchased, what I gifted to, not let the old man come, Lord. He will not after hearing him only, Lord. Otherwise, I said I will give NOC. After hearing him, Lord.
Why will you give NOC?
Because, Lord, I don't want to get into these details, Lord. They come and say their own kind of difficulties, what they have faced, what they have suffered. And only because this is my only
Right of maintenance of this lady will prevail over all other rights, including succession rights. I am telling you, I'll write that judgment in this case.
that TVC,
In the absence of her husband, who will maintain her?
TVC, she already filed.
Whatever it is, I am telling you, read this provision. Section 26, any relief available under section 18, 19, 20, 21, 22 may be sought in any legal proceeding before civil court, family court, criminal court. This analogy will be extended. Do you think when criminal court, civil court can pass order, High Court cannot pass order in 226? Then I will pass order. Any proceeding affecting agreed person and whether respondent and the respondent whether such proceeding was initiated before or after commencement of the act. I will protect her interest.
Lord, I'm not coming in the label.
Ask father and son to come.
Lord, participant given date, Lord.
మీరు లాయర్ ని పెట్టుకోండి, మీకు కొద్దిగా సరిగా లీగల్ అడ్వైస్ వస్తుంది. కోర్టు పెడుతుందని చెప్పినాను కదా మీరు. Kavita Yadav was appointed by legal service authority.
No, Lord,
Atmalata Yadav.
But she only gave Vakala. Even Loha. Even I tried to contact, but the phone number is also not.
Which మీ ఊరు ఎక్కడ?
Hard good.
Where is this village?
But in my
Which mandal?
village and here it was how it is.
Shamshabad mandal. Shadnagar. Shadnagar. Four, 5, 8, 3. Can you call father also?
I call because he will explain all the things about the lots will get clarity.
According to you, how much extent is willing to give?
But,
Remaining 24 acres according to your client is ancestral property.
This property is 15 acres, 38 hectares, that is a different survey number that it came to.
Not covered by this case.
Not the details, RDO order clearly specifies those details. Ancestral property is in 3.7A, 7 acre 21 hectares. Page number.
So this 392, 387 total is unconnected with ancestral property. Same village?
Same village. Lots of kindly take page number 59 of secondary plot, that is 4583. 59, paragraph number 98, the ancestral property details were given. So what are ancestral properties which came to father?
Where?
Page number 59, your lord.
59 is a gift settlement deed. Second.
Paragraph number 90.
Yes.
Not survey number 3075 is 7 acre 21 hectares. TSHC is 30. 57 is 4 acre 28 hectares. Survey number 230 totally 15 acres 38 hectares. In survey number 57, this 4 acre 28 hectares are sold. How Miller? How this is related to 38, 312, 313, 315, 316, 390. These are no registered sale deed. She been asking in this period, that would have been.
What is the proof that he purchased these lands with his salary?
Not even a government employee teacher, and he is well. Not also, I will call the parties, not that will give more clarity.
How can you say that with sale proceeds or benefits arising out of this land, he has not purchased?
The lordship knows what is the value of land, then those entire area, lot of lot person will.
I know everything. I am feeling I know everything.
No, my lord. The lordships are telling.
1974, according to me, prime office, I am telling you. 1974, if he has purchased, it is with ancestral joint family nucleus only.
All the parties, the lordship queries, they will answer.
When did he get his job as a teacher? How did he earn in 1974? What is his age? What is the age of father today?
Not party anymore.
Within 3, 4, 5 years, he earned so much as salary. Salary might have been 200 rupees.
He is now age about nearly 80.
80. I know what is the salary. You tell me. My grandfather was there in Nizam administration. I will tell you what is the salary then.
But even land values are like that only, my lord, at that point of time, in 1990.
I am telling you, his salary might not have been 200 rupees also. Not even 200 rupees by that time.
Just through sale deed, not time that.
If you let us see what is the sale consideration. This is only with the joint family or ancestral nucleus. 1974 sale deed, show me.
But page number 40, lot, kindly see this is.
Sale deed.
Only these sale deeds, but for father.
It is there. Page 100.
98 is there.
One document is in 1980.
1918 because this is 8,500.
You want me to issue summons or you will get it?
My lord, I'll ask him to come.
Learned counsel for the petition. అంటే ఏం జడ్జిమెంట్ ఇవ్వద్దా నేను మీ దిక్కు కూడా జడ్జిమెంట్ ఇవ్వద్దా yes GP this is a case where one son younger son claiming that father gave two registered gift certificates. According to Mr. Kalmon, father was a teacher, 1974, he purchased. So when she approached revenue authorities, they said these are ancestral property, 50% share. 50%. Unfortunately, father is alive. How will she get 50%? She will get only 1/3, even assuming that it is ancestral property. She will claim 50%. How this person, the authorities said it is 50%. Humanitarian grounds, 1/3 can become 1/2. Someone should explain her. I did my best, but unfortunately, petition.
Done.
10.
Item 36, Mr. M. Damodar Reddy.
Already planned are private and
Item 43, 44. Item that is Mahadev.
43, 44.
44 is my lord, it is the matter pertains to the trust.
Trust
That
matter.
Maharaja Krishna Prasad's trust, my lord.
Yes.
Your lordships on that day said, my lord, suppose if the roaster is continued, your lordships will hear the matter. Fortunate, we are very fortunate the bench is continuing, my lord. Your lordships may kindly safeguard the interest of the parties, maintain the status quo with regard to creation of this title of the other parties.
All of you, I request you to wait for some more time.
Yes, we'll wait.
Madam, because
Yes, my lord.
may not say anything. Just we'll wait for 2 weeks.
Yes.
Yes, madam, you are any urgency?
Yes, my lord.
Item 43.
I thought,
You wanted interim order to be vacated. There was an interim order in your favor.
Yes, yes. I find that.
Still, did I pass limited order?
No, it's not a limited, one. It is here subject to the result of the inspection, that's all, it will protect the letter. Can we?
Forty-five, the case to me.
Regularized Ada Behana. Yes, after December 1812.
46, the Rajinikanth Reddy.
Jagdish.
Respondent number 7, my lord.
Asu.
Respond number 7 at 5 count. I need to file complaint. There is urgent because I will just.
You want time?
Yes.
Request of learned counsel for. Next. 47.
Article 47, Narendra Nayak.
Time this, RH.
Any urgency? You are OL, huh?
No, our role is very limited.
Now, after new company act has come into force, what? No, this is old case. What is the role of OL now? Old cases. You want some more time, huh?
We fight normal.
Who is the contesting party?
Contesting respondents are the
Ram Mohan Reddy.
Really what we are seeking for is survey was connected.
In the name of GP revenue.
Item 48.
In the meantime, counter if any to be filed by the OL. 2011. Let the OL file counter because our, you know, the.
Property are being purchased by way of an auction matter.
You know the official respondents, even if they have to concede, they will file counter.
Property has been purchased subsequent to purchasing by way of an auction.
What auction?
What auction? An encroachers have encroached upon the property. Our limited relief is against.
Go through the papers.
But they should not they state that order.
Yes, 2011 I will just come up. Construction of Dhobi Ghat. Mancherial Dhobi Ghat. What do you say? There is a Dhobi Ghat there?
Lordship kindly page 75 now.
Is there a washing facility there?
No, my lord, now they are giving it for construction of Jodi Ghat in the land of the petitioner. And the Lordship kindly even an application of page 75, 76, 77.
Page 78. But page 75, my lord, they state that my lord, the house number could not state that my lord,
Municipal number was allotted earlier.
finished, my lord.
Municipal numbers were allotted, they were there without notice, not without notice. But even they applied for applying, the Lordship can see page 75, 76, 77. Apply application.
What do you say?
Survey number dispute.
Request of learned.
There are 3 plots. But in one of the plots
Sir Hanumantrao, if there were no pillars, I would have granted interim order.
application for FIN is pending. Let them conduct a survey.
I will, if you want, I'll grant that direction, but not, no status quo.
Till such time, not in Lordship can is even.
Pillars are raised, what can be done?
I handed a constructor in the port. Now they started. Now the.
It's for benefit of socially deprived class.
How can they take the plots of the individuals? I have filed sale in 2011. Now without any notice.
Government land.
No. Okay, let them consider.
The request.
Occupied is, let's say, occupied is,
15 level. Give him advice, directing him to survey. Next. You also, I thought only senior councils have that privilege. So why are you taking off during working days? When do you want?
That they can get tomorrow also. It was at 10.
They have problem now because of election.
These matters.
Officers are not available according to.
Only limited trade is pending survey.
Cannot. 2011.
Item 49, Sir Hariharan.
Request of.
Item 15, Ms. Rasna.
Same.
Page number 4, item 51.
This petition that I complained is filed before the official respondent. Complaint will not for certification of the complaint by the official respondent. Non-disposal of the
Inquiry of sale certificate.
sales certificate.
Coming for the first time after 1 year.
Yes, my lord.
GP.
Sales certificate of 29/1960. The quarterly document, lord. Attention there.
Yes, whatever it is.
Settlement officer.
Mr. Nageswara Rao.
Land.
8 months back, you were not granted interim order. Request of learned GP. Not granted interim order now after 8 months. How can I grant next case? Let us see.
Item 53, Mr. Panikumar.
That in this I am appearing online, my lords. My reply is ready, my lord. If your lordship may kindly post it tomorrow, my lord, I will file the reply in the registry, my lords. My lord, in the counter, unfortunately, my lord, the parties has given the description.
For Miss Madhavi.
Item 54, Mr. Aisha Sabah.
Awesome. 55, 56 also, I hear.
They have given the counter today, my lord. Next Monday, your lordship. They are fine, reflect.
Yes, sir. Never.
My lord, my matter is urgent, my lords.
File a counter or interim order be granted.
One day or the other, you have to file counter. So whether he insists or not, you have to file.
We are giving and they just want to file counter. What is it?
Other matters I will take up after lunch. Mr. Soni, your matter also after lunch. Mr. Ram Gopal Rao.
Motions.
Just 105. Sure. Where the authorities have take action, the additional adjudicative officers informed that they are going to take instructions with regard to what action they are taken, basing on the letter addressed by the CCLA to the Chief Secretary. He was reported to the Honorable Supreme Court with the matter is pending. Increases 3 days tomorrow. Which one? 105. That also I made a mention, but the board will not be reached. One matter to be taken up at 2:30 minutes. Today it was the post may not reach. What is the matter? That is relating to the writing where the decision of Watson quoted was quoted one.
Yes.
It's always yes to yes.
Let it be declared in the report.
It's not a report. The CCLA has reported. I granted interim order. No. It will be challenged the inaction of the the matter where CCLA has reported the fraud played by the persons before this honorable court as well as the in their office. And they directed to take action. They did not take action on the said letter. So that is the reason we come straight to file a writ petition. What action they have taken? Your lordship has directed to learn the facility to get instruction. What action they have taken? Despite of this, there is no action. I have too many 2:30 matters. I post it. Tomorrow. Tomorrow. Only they need to inform that the government itself it come at 2:30. Ask your. Let him come.
So let's just kind of second was 123, 100. But we are being informed that Kinecons Ravindra has some personal expertise. And Kinecons facility held up another smarter matters for them. All the Kinecons they agreed for Thursday 2:30.
Yes.
But this 105
Thursday. 105 also Thursday.
2:30 same.
Yes. Yes. Taking up. Other matters will be called at 2:30. One. I'll give the slip.
Here is the vacancy.
Please give me solution.
Last question, the vacancy.
Why was he again examined second time?
They have trans. Be first time they went, first time in Milord, just they looked at the Sadaram certificate which was given by the particular district and they given the 30 without any check, any examination. So therefore only again it made a complaint and with the help of the doctors on 11th July, 30th July and 14th July, 3 days, not just single day, not single this one. And then finally they gave me 60%. So that is the very authentic. Therefore, based on that one, second responding to that.
1 minute was.
They profession also declared. Now somebody has to report in this case. No. Who is not a party to this court.
He's giving a principle.
Yes. There's the last but 1 minute. Ranga.
Have you given copy?
As per the notification after completion of the recruitment, they mentioned that in Rangareddy there are 3 post millers. Kindly see the last but 1 millers. Rangareddy, the last column, 03. Number of unfilled PH vacancies for the reasons no further eligible candidates or number of vacancies kept vacant or withheld on the reasons of medical mentioned in the selection notification are due to 4 cases. So there are 3 cases, 3 vacancies pending in Rangareddy where the VH candidate is eligible. And also mirrors the next page. Next page, in the note, the second after second tabular form, there is a note, and in which the second one is second note. The 41 fresh PH vacancies left unfilled due to non-availability of the eligible candidates. So there are plenty of vacancies in the 2017. That's the 2017 notification itself.
What about what about VH?
You also may look at the official data of the commission. What my friend has given, no headline report.
That's fine. That's
You also look at this official data of the officer is coming.
The vacancies?
All preliminary. My friend knows it.
Why don't you file new writ petition? No, I'll record statement of Mr. Ram Gopal Rao. I'll say whenever new vacancies arise, you will be accommodated.
Yes, therefore, this
I am notification statement.
kindly allocate
If we want to, any vacancies are there, let it be represented.
Let vacancies are there, mirrors in the new notification also.
I underline, highlighted with orange color. So for Rangareddy is concerned, the Ramakrishna state. This fiscal handicap, my lordship said that. With the PH, HH, OH. We had third from table. Third. My concern with PH. You also may look at one vacancy, general for unreserved. That is, anybody can compete from that post for the merit. If it belongs to Rangareddy district, there is no government vacancy for him. As per this information.
This
PH. And women is 5, general is 5.
column number.
PH, that heading. After ST, PH is there, mentioned OH. And your Rangareddy is concerned serial number 8.
PH, HH and OH.
Yes. Lord Rangareddy serial number 8.
PH, it is
Your PH, it is one vacancy.
L. L means
Local.
local.
One vacancy for general.
From where are you getting general?
Unreserved. You are means unreserved. The heading.
You are means unreserved.
Unreserved, it goes to anybody, that is one vacancy for general.
Yes.
Male, female, local, non-local, anybody can compete for that vacancy. General unreserved. That has been filled. Now coming to your next column, local category, 5 for women, 5 for general. So women he cannot come, and 5 for general he can come. As per the merit millard, he was not there, all the candidates have been filled. If anybody wants to renew millard, he has to make them part in the general category. Yes. The Rangareddy position is concerned.
LB means
Local bodies.
local bodies.
The Jilla Parishad schools. 5 for general, 5 for women, 5 for general. 5 for general, 5 for women. 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 5 for general
you file one writ petition, I think you can be accommodated.
Again.
Vacancies are.
In the content, they can't be in other direction, we got to open. My friend knows it, why it has come from my mouth. The content is complete or not, it has been applied, saying that we are so and so, two different reports, what to do at this stage. But if any vacancies are there, without disturbing the appointed candidates, this case may be considered. If any vacancies are.
You want me to record that submission saying that without recording?
I cannot commit on behalf, because if you want to replace somebody, you have to make him party. But 3-4 years.
No,
back,
without disturbing any person.
without disturbing, 3 years, 4 years back, the appointed, the profession has been declared.
Without disturbing them in case future
If any
vacancies.
vacancies are there, we will not make vacancies.
And listen. Vacancy positions are very clear.
How can I pass order in this content case?
The point here is clear.
I will only record for your benefit, I will record 60% disability is there for this person, 40% for that lady. I will record. And I cannot pass any further orders. I give you liberty to file the petition, noting attention of Mr. Ram Gopal Rao. There are no vacancies of, even for that lady, no vacancies.
No vacancies.
There are 25 vacancies in Adilabad. And how can they can say that no vacancies? And how can we take that into consideration? The second one is the Adilabad district, where 25 vacancies are there. And vacancies under the PH category.
OH, now it comes under orthopedic.
There is
Column number 1.
What's in your favor by Pilot, column OH, serial number 1, Adilabad is concerned. Pilot comes under OH. Reserved Pilot general 1 and local 1 goes to the women, 3 for gender. Total 5 vacancies are being distributed. 25 vacancies second. This is a distribution of vacancy as per notification number 53 of 2017, where you are appearing for this. General statement.
Not general statement. Look at this one. This is the TSPSC. It's there.
He's giving official information. Sir, Ram Gopal Rao is giving official information, you get instructions.
It's not official. That's the point. This is also official on their website itself.
There is a stamp of the assistant secretary. I have to go by this document.
May I submit this one? They filed the counter in another repetition with the vacancy position. And now they are changing this, turning around and saying that no vacancies are there. Therefore, whenever they are stating something, it's only as per the requirement.
You do one thing, have you received this? Please verify and come back.
Yes, may I ask this one? Just only the point here is that your lordship passed the.
They are saying.
Can you submit one? Your lordship passed the judgment on two folds. One is for the testing, and the second one is if they qualify within 4 days, they have to provide the employment. So that's the second part of your lordship judgment. So therefore, that is not complete. So therefore, we hear before this honorable. So therefore, they cannot say that no, the contempt case it cannot be done. My point here is
they are giving reasonable explanation, saying that they cannot disturb one all incumbent.
Don't discuss there because the first one they
we are going back to the same problem. They have given official information. There are no vacancies. If you have better information than this, you come back with that information.
My lordship, Secretary Commissioner, this
this is what we
Secretary Madam Chepin the important government standing council is official information. I have to go with Uttari TH Gadindi, Uttari TSHC future vacancies to consider this. Jobs lekunte nene ekkada create chesi ivali. From where will I create a job? I cannot create a vacancy. You should understand.
No, this is the official counter they filed with us. And where they explicitly mentioned that this 25.
This all will be on the expedition that get better.
No, because no, they cannot change the version again and again. In the one repetition, the file.
Please file in the form of affidavit. This one. That will solve the problem. That will solve the problem.
Lordship will direct
Motion matter. The Damodar Mudra.
Is the council who filed indeed application, Mr. Nevertheless matter. No, that is it. Today morning your colleague received papers, you are filing counter to that? Yes. They did come, they want to file counter.
Bless.
No. According to that policy, papers were served, signature of some other person. So anyhow, in the morning, your colleague served additional set.
Yes. The Damodar Mudra.
That is a lot. The result is very much acting the action of the respondents without acquiring land, without any notification or notice. They have come up and started leveling the my property for road winding. The page number 37, it's a photographs. Within the left hand corner,
this is a road.
Road winding. Without any notification, without any compensation, without acquiring any land, they are simply coming upon my property and taking the land. In the opposite side of my road, they are marked to 9 feet, but have leveled up to only 3 feet. And in my property, they are coming up to 18 feet.
Yes, what do you say? Also accepts we have a respondent number 4.
It says agricultural land. The prayer may not it says it's agricultural land.
It's an agricultural land.
Not it shows not what is it that is not
You have land behind this building.
No, page number 38. The second photo, the left hand side is my land, The building portion, is my opposite to my
second photo.
Yes, second photo where the Innova car is there. That's my land.
Why did you combine all 3 photos?
I intend to show my lot on the opposite. That's the building opposite to my property, wherein they mark 9 feet, but have taken 3 feet. And in my property, they are coming to 18 feet under the influence from.
You are, madam? Revenue. AGP. $28.11.
Instead of 28, then can request for after on 1st or 2nd of December. First one inconvenience.
You have such a long plan.
My sister's
An
marriage.
advanced planning schedule.
My sister's marriage is there.
Hope you are also not going to foreign countries like others who have mentioned before lunch. Wedding, of course, I can understand. So I was asking many lawyers during working days how they are going to foreign destinations and on tours, which privilege I did not have. See the second photograph. He has combined it and it is creating a confusion. First photo, no, you see the color photo. Whenever you file from now onwards, why don't you give color photographs to the government leader?
I'll make sure for the next time.
open land, not this one.
This land is the second photograph. In the front of the property, you can physically see In haphazard manner, they are demolishing the property. Person actually, the person who is having house, he should have come to the court. We do not know.
He has not come to
Now the cable wires are visible.
He has not come to the court because he is influenced of 9 feet, only 3 feet of his land is being taken. And the other, for the other remaining, they are encroaching my land. Yes.
Yes.
The action of the respondent for indicating the peaceful condition. That page number 15 is my deed of convenience.
After regularization, why will they interfere?
After regularization, I paid a consideration, everything is annexed. My lordship may see the photographs. They say that, that which is of 2/11/2023. There is no construction at all. There was a old depleting building, I demolished it. Like on the day of removing the debris from it, they come and say, this land is in the lot, it will be so and so land.
Lot of the petition to
Bless you. Page number 9, specially identified cases. Item number 111, Kullara building.
Laura. You have instructions. On that day, I told you, madam. Information is taken care of by information technology.
The 112, Mr. Gori.
For presentation on.
Item 130, Mr. Sri Purushottam Reddy.
May it please your lordships.
Who is the respondent?
Lord, on the last occasion, the respondents were advised to get instructions, Lord.
Madam, here also your name is not there. The name of so and so post tomorrow. Information technology, GP man. First two matters name was printed, in third matter name is not printed. Let it come tomorrow.
Very well, my lord. Obliged, my lord.
Item 114, 115. K. Venumal.
Already this year. Even though the stocks are as per the specifications as indicated in the consent UMS number 21, without looking into the same period, simply period they rejected. Even in the counter affidavit, your last time permissible merit variation is not at all quoted.
Did you read the counter affidavit? In the tabulated column, you have given the variation, the permissible limits. It is within the permissible limits according to learned counsel. Which paragraphs?
Paragraph 4, your last merit in the counter file in this WP 21874 of 2019. Wrongly quoting that against the GO. GO they filed in the counter merit WP 242 of 320, page number 15, your last merit.
This variation is not as per revised guidelines. So here, go to page 3, para 4.
Yes, sir.
Maximum limit allowed 25.
Correct.
Analysis found.
This is incorrect. Your last merit I see this is contrary to the GO. It's contrary to the GO.
GO number?
Yes, GOMS number 21. Page 15, your last merit. Next 3. Last spec I see the fractions and column number top pillar 4. Maximum limit, that is the percentage as per uniform specifications, grade A, common and common. So last spec I see next column, maximum permissible limit
From where did you get this information? 25
They falsely indicating the same through
previous GO.
upon their own time, they want to restrict my stock, they have indicated the same.
There should be some basis for that.
Yes. Without there being any basis, contrary to the GO file, but it is filed by them, seems to be followed by them.
AGP, compare this statement with paragraph 4. You are saying permissible limit is 30.
Mine is 29.10.
So, no, actually, minimum limit is there.
Yes.
Maximum limit he has not shown.
Yes, not sure. Ignoring that, they are saying that it is not as per specification, therefore rejected.
Token rice, so
Yeah.
30 maximum.
Yes.
He has grains,
Yes.
13, 16.
Right. All are there permissible. It's 14.50.
Yes. First one is for season.
But not rejecting to receive the stocks. First one is.
What relief can be granted now?
On behalf of the stocks which are supplied by me, it is in their go down only. They have to receive it.
What will they do after 4 years?
But it is in their go down only. I have not taken back it to be my respect.
Broken rice and DS price, what is the shelf life?
It's not good, but it's a rice platter.
What is the shelf life?
The gold it will get more price. The value of the gold.
I thought only liquor value will enhance by becoming. I didn't know. Food grains
Gold rice
also
yes.
will have enhanced value
Yes, correct.
if it is stored for a long time.
Now it become gold, then it will get more value. Because no new rice will
Yes. He is saying if it is stored for a long time, the value will increase. I don't think so.
But it is in there only, that's why I also made the. Wherever the corporation has also responded.
As of now, I have come across cases where the PDS rice purchased on subsidized price of 1 rupee in Telangana state is being sold for 13 to 15 rupees in Karnataka state and other states for poultry feed. How do you think this rice will have more value? Broken rice.
Not broken rice.
When people are not eating the subsidized rice, according to them, they are getting better quality rice. And you told me on that day when you were in the court.
Whenever the good rice is there, they are taking.
So I am waiting for that case. If people are not interested in the subsidized rice, why they are receiving that? I will direct the government to stop subsidy, rice subsidy, and reframe their policy. Why? They are receiving the stock and diverting it to poultry farms. I have come across 7 or 8 cases. If it is not fit for human consumption, why should they receive subsidy? At least they can utilize this for better public purposes. They will pass orders.
Second case, because of not receiving the stock, they are saying that they have not.
Consequential proceeding.
Yes, yes. Right.
How much time? You will continue, no, today?
The other side is going.
No, if both the senior counsel are here, what I am proposing to do is I will adjourn all other cases so that lawyers don't have to wait. Kindly wait for some time.
Pass over matter item 16.
Discuss.
You pass out this and only pass out.
Item 16, Mr. Shashidhar. Mr. Ajay Kumar.
They said information is furnished. As per judgment of Supreme Court in Rajneesh versus Neha, you will get information. The family court is bound to direct husband and wife to file income statement. Why are you filing RTI application?
Now we have to find the assets and liabilities in the.
So why are you coming to the court under RTI?
They are not furnishing.
Why they will not furnish?
Family court
It's a
asks nothing.
Supreme Court said it is mandatory.
But they are not. Family courts also not entertaining the application.
One matter was argued before me, that direction is applicable even to the pending cases. Where is it? Exempted. Instructions each. They are saying this intelligence wing and security organizations of the state establishment are exempted under subsection 4, section 24 of Right to Information. Exempted. This organization is exempted. What is the name of this, madam? APSP.
ESS.
I'll pass orders. If you want, if you have filed application before family court, I would have directed family court to pass orders. It is mandatory.
matter, Mr. B. Suraya. Similar circumstances. Item 120, 121, Mr. Security. One minute. Item 157, 58, 59, the Basant Kumar Soni, 14%.
Any progress in the Supreme Court? Okay, you want to argue this?
There is no urgency, this matter is important, my lords, it requires some consideration, my lords, in larger public interest. I think Rishi is
No,
there.
if you want, I will hear.
Senior counsel. It is as per my humble.
When do you want?
As per my lord's convenience, no issue, my lords, I will argue any day, but my lords may make it up, top of the list.
Since matter is there before Supreme Court.
These are not, these three matters are not connected.
Not this one.
One of the three is connected to the other matter. No, my lords, no, my lords, again, wrong statement, my lords, all due respect, my lords. My lords, with all due respect, my lords, the matter in which Mr. Ramachandran is appearing, that is somewhat related, my lords, that is also, they are trying to connect it, that it is also not connected, my lords. The only reason
Next week.
Here the issue that
Next week.
from my lords. And last occasion I was out of the list, even.
Don't worry, see, there is difficulty. See, there is no point in having. There's no point in having 300, 400 matters and making all the lawyers sit here waiting for. So it's better to have 150 matters and complete the entire list.
Well, next, Mr. Rishi Reddy.
All other matters. It will take time, I think, no, Mr. Prakash Reddy. Yes. So I am requesting all other lawyers, I am adjourning all the cases. You mentioned matters will come tomorrow, day after. Instead of waiting here, better all the matters are given in respect.
My matters, my colleague made a mention with respect to two matters, 89 and 106.
GP assignment. They wanted tomorrow, Mr. Mohan.
Yes, my lord, at 2:30, your lordship may say, my lord,
Tomorrow.
Tomorrow at 2:30.
Yes, tomorrow 2:30.
Item 61 and 62.
That's too much.
Item 61 and 62. Responded. Because Lordship had heard this matter at some length. The only question was whether the land in which the respondent has land, whether it falls in agency area or not. Lordship directed us to produce the gazette notification. Gazette notification has been filed by the petitioner and the land is not in the agency area.
There is urgency and take up tomorrow.
Without any due process, there is an interim order.
Yes, tomorrow.
In the motion.
All matters, I am completing the entire list.
Because that's the only question which Lordship wanted
Page.
clarification.
I request all of you, I'll call page wise, I am giving dates in all the matters.
Page number 4, item 51 to 64.
Yes, I have noted next. 60.
Page number 5.
Panchayat secretary matter. Writ appeal. Writ appeal judgment, what are 811.
Page number 5, item 65 to 75.
66.
Yes.
And take up tomorrow. For extension.
Extension of interim order. The Begumpet land. Same where seized vehicles were kept.
Yes.
No, if Lakshmikant is there, I will extend it.
His colleague is there. Next week we will try counter minute.
Item
67, 68, 69 will come tomorrow. 71, you are for?
There is one more matter that is not listed today.
Give the number.
3005.
Madam, if you hold the cell phone and see it in the court, why can't you write it on your file and mention? No, from tomorrow onwards, I'll do one thing. I'll ask all the lawyers to hold cell phones and argue. Better. Then you see how the scene. Now the proceedings are live streamed. You do one thing. You sit in your office and watch what is happening. Then you will understand. Why can't you write on your? You have a diary. Why don't you write in your diary? I'll do one thing. I will also hold a cell phone. And I'll say I'll read it from. Why should I read all the files? When you have a diary, why don't you read? Yes. When do you want post along with so and so? Not tomorrow. Why? Thursday.
Page number 6, item 76 to 91.
Item number 85.
Yes. I said I'll accommodate from tomorrow till Friday. All matters will come in motion list. Next.
Page number 7, item 92 to 106.
Come at 4:30. If it is only Dharani and F lines, come at 4:30. I'll pass it over. Representation under which act? 3080. Tomorrow. Yes.
Page number 8, item 107 to 110. Item 10, item 120 to 121.
Item number 117, my lordship, in the morning I have mentioned this case tomorrow. So it will be taken tomorrow, my lordship.
Yes.
Motion list, my
Mentioned matters will
On the 18th, my lord. On the 18th, I did take up.
all mentioned matters tomorrow will come tomorrow in motion list. I'll say.
Wednesday.
Go on Wednesday. Yes.
Motion list.
item number 78.
Yes. 74.
Content. GP assignment. Yes.
Number 87.
If everyone wants tomorrow, what should happen to tomorrow's matter? 80?
87.
87.
So basically,
Yes.
maybe it's not coming tomorrow. Item 75 tomorrow.
You want 3 weeks time.
3 weeks now.
You want 3 weeks time.
I'm not in the cinema.
And the, after the final critical. So it's a private problem. And it's not a theory. Not much.
Is there any urgency? It can be
Not
allotted.
this one.
2811.
3 weeks.
2811.
Okay.
Yes, sir. After completing the arguments regarding the patient aspect of the argument, prolongation by issue number 8 and 9, which have been decided by the arbitral tribunal. Well, only to recapture it, what is the because the tribunal will consider. But this claim number 1. Amount claim by on account of the prolongation, where as merchants know. Where implemented the 36 from 2006 to 2009, was supposed to meet. But because of the fact, there were delays in handing over the science, there were evidences which they were supposed to clear. Whereas they could not do it, but as they continue for a longer period than the original contract period. Not only that, but they have not taken over. But they have given the taking over certificate, but with retrospective effect in 2013, retrospective effect of 2011. I'm only just recapping what was argued earlier. But this has been considered from 202 onwards, but in the award. The lordships are holding the same application number 1 of 2020, papers filed along with the application. Before application, 202, the original set of papers were written. Just copy and they all. This is where the lordships perceive originally no doubt. Amount was claimed including the period of the 2013. But it has been later amended before the arbitral tribunal itself from 149 to 131, removing the period after the taking over. My friend actually argued saying, giving this amount, claim amount, sanctioning this claim amount, even beyond the period of taking over certificate, during the period defect liability period, which is sufficient. Factually, with great respect to my men, subject to what my friend would like to argue. And no doubt it was included in the claim, originally this 149 crores. But it has been reduced only up to 2011 by way of an amendment, which has been brought before the third arbitrators general that 2 unamended and amended portions have been filed before the Supreme Court is closed. Period has been reduced and claim is only confined to 2011. Up till the date of taking over certificates, your lordships will find that in 202, your lordships will see original statement of claim. Amount claim as per the original statement of claim is 149. At 202 minute. May I refer to internal page minute, page 56, at the bottom internal page mention is there. Yes. Yes. I refer to the internal page minute, one page is not. Daddy. Your lordship perceive minute amount of claim as per the original statements of claim is 149. Amount of claim as per the amended SOC is 98 crores. Interest of 10% till 31st January, that is 32, including interest, correct? Total amount has come to 131. If it is original claim, it would have been much more. So this has been corrected, correct? Only up to that date because that is the reason why my submission to lordship could be the premise on which it has been argued, saying that even beyond the period of the taking over, this prolongation period has been counted is factually incorrect in my submission. And in fact, this has been corrected, even with the arbitral tribunal. Arbitral tribunal has taken into consideration the amended claim, granted also that one. There are two with regard to this prolongation task. On the site expenditure and off-site expenditure. In both of them, we have corrected it to date 2011 itself, not as submitted up to 2013. May 2013 is the original claim. It has been now brought back to 2011. That is wrong, it has been reduced, that period has been reduced. But in this case, as I said, taking over certificate has been given much later. As on the date of the taking over certificate, only when we have counted, not every year. But merely because they have given the retrospective effect to the taking over. But I cannot be blamed for that, it is for them why they have not given. And your lordship to see the amended claim alone has been taken into consideration. That is the main purpose of pointing out this. And I've seen how I've shown to your lordship how elaborately all the clauses of the agreement have been considered by the arbitral tribunal to come to the conclusion. And as I heard my friend said the entire delay has been attributed to me as if I have not committed any delay was the submission. But with great respect, when it is the delays are being considered, it is the person who has invited the tender should be ready with the promises which he has made in the tender document to say that this will be free of encumbrance and you will be free to carry out the work. My obligation is only to carry out the work. And it is not the case of the department or the applicant before this honorable court saying that I was not ready with the wherewithal, men and machinery which is required for the purpose of execution. In fact, my case is I could have completed even in a earlier to the period which has been given and I could have claimed the bonus, but for the fact that they delayed and given the project site related because they were supposed to give me in 7 days time. And my friend's submission was because it is not a vertical building, as it is horizontal road, wherever I give them the piece, they can do it. In fact, I showed you the chart. There were several hindrances at every place. Some are electrical problems, some are access, and some are objections to the local people. I've given the chart, which has also been considered. This was placed before the arbitration. And before just I was showing you the chart. The other day, at that point of time, some other matters chart was placed before the arbitral tribunal. This chart gives an indication that how the delays have been caused. Roughly about 10 kilometers odd is the length which has been subject matter the contract which the payment has made. What is permission? We can use the legend of the colors. We will also give it to the other side. But for the convenience of the court, I've asked to prepare these are the various colors, where your lordship must see, this blue color, hindrance due to electrical utility. Lordship got it, yes. And then, the other color, the hindrance due to road alignment, change of EFC drawings. And then, another color, late handing over of site. Additional structural work, stoppage of work, additional work. Your lordship got it. If your lordship look at every chainage work, all through. But there were hindrances. So, the argument saying that wherever we have given, I can understand some small portion of it has not been handed over. But enabling me to complete this chart has been referred to, I'll point out to your the arbitral tribunal findings before coming to the conclusion that they are responsible for the delay. And I could not have done anything. My friend says the entire delay is attributable to me. I can understand. If I am required to do acquisition, there may be some delay. I have only a contractor. The site which is handed over to me, I need to execute the work. It is nobody's case, including the applicant here, saying that I was not having the wherewithal that there is any delay because the machinery which is required for carrying out the work was unavailable with me. And the men and machinery was unavailable with me is not case. Is not the case. What all they say is, wherever I gave, we should have done that work. I showed you what the entire chart, which will clearly depict in all the change of 10 kilometers, there was one problem or the other. So that is how it has been delayed. Now, with this background, long back I have taken your lordship through relevant portions, but I would like to again point out how meticulously and detailedly the arbitral tribunal has considered. This I am doing for the purpose of saying grounds for the International Commercial Arbitration Award interference are very narrowed down. Because earlier it was expanded, then there was an amendment, and including the ground which is available with regard to national commercial, that is domestic commercial arbitrations is also not available in case of international commercial arbitration. It has been narrowed down. When I point out the case law, I will point out the logic. Scope for interference is very narrow, as it is not an appeal for reappreciation of the entire evidence. Because my friend tried to give an impression as if it's a windfall. In fact, when the contractor of this magnitude and the contractor who has got the wherewithal to complete the work even before the scheduled period, bringing the entire machinery and men which is required to be done, required to be attended to, and prolonging the matter for more than 2.5 years certainly will cost. In fact, last time also I pointed out it has to recap. Many times I've asked, saying that permit me to demobilize. Or if you reduce the scope of the work and say that you get it done to some other agency, let me move from the place so that this cost would have been reduced, which has also been dealt with by the arbitral tribunal. I point out to you. But may I just run through the various paragraphs, maybe it is a repetition, but nonetheless, because this is the major claim. What subject to what your lordship say, I would like to complete this claim. I will try to complete this claim today. And if something spills over also, if your lordship give some other date, convenient to your lordship, but some other dates, I will be able to complete the entire act. In any case, today, matter will not be possible. Subject to the convenience of my friend, 2 more dates are given to me. We both will try to complete those 2 days. If not, it might be my friend required because it's replied. But your lordship say, your lordship, for the convenience, Mr. Lordship's permission, note which I have asked my friends to prepare. For the convenience of the court. Because record is very bulky, because Analyzing the various paragraphs on which the arbitral tribunal has considered this. While keeping it side by side, I go to the original paragraphs also. The Lordship perceive para 1.05 at page 203. I read this one. The general conditions of the contract of bidding conditions, fixed edition, so with further amendments made to the conditions. Further amendments were made to these documents to the corresponding issue. Contract had a specific provision for grant of extension of time for completion and payments of additional costs and compensation as possible. Delay in supply of the drawings, failure to give the position at site, delay due to non-foreseeable physical obstruction of the conditions, delay due to the suspense of the works by engineers resulting from the requirements under 20.4, clause 40.2 general condition GCC word, that general contract conditions. And then your lordship perceive E. Technical specifications by so and so and so. Lists of the employer's risk and includes injury here, risk arising of design of permanent work, class 44 of GCC. Entered the payment by extension of time for completion of the works, various reasons. Mentioned therein, other than the contract of breach of default. The schedule for handing over the site and access thereto as mentioned at the schedule A of section 8, volume 2 of the contract is as follows. Within the time stipulated, for commencement of the work in the appendix to the bid in accordance with clause 41.1, that is within 7 days from the date of the commencement. I have given the chart explaining the delay. How many months and years they have taken handing over the site to. This is between 11 to 24 kilometers. After 3 months of commencement, all the junction. But the other portions, they are supposed to give in 7 days. Only junctions, 3 months time has been given. For all the portions, there was delay in handing over the site to me, enabling me to carry out the work. It is further pointed out. And then I did not run the lordship. It is further pointed out that in response to the pre-bid meeting clarifications to specific query on land status, respondents replied stating, as per the bidding documents, serial number so and so part conditions of thus, even on the specific query by the bidders, the respondent has confirmed that site shall be handed over as provided in the bidding document. Lordships perceive not only it indicates in the bids, but which will be the governing factor for anybody who is coming forward to bid. Noticing what has been said, in 7 days it will be given, in junctions it will be given in 3 months. But they will get ready to come forward for bidding. And then in the specific meeting which has been held in the pre-bid meeting, they said we are ready and will be giving site within the dates promised in the bid document, even on that day. So that's how bid has been taken place, and in fact I was adjudged as the lowest bidder. That's how I've been awarded to. Thereafter, experience which has been realized by the contractor is that they could not give the access to the many fronts, including the land, electrical, so many objections, obstructions were there, which have not been cleared in time as promised. That is how prolongation has occurred. So that is the reason that all these factors have been considered in detail. Your Lordship specifically. Bid submitted by the claimant included the program for completion of the work method statement. The program was prepared based on the conditions at 205 top. Based on the conditions of the contract for handing over the site drawings, instructions, release of the due payments in time. The price quoted by the claimant for execution of the work as per the given scope, the schedule and other conditions of the contract. So then the contractor has therefore submitted the bid based on the data information provided at the bid stage and the conditions of the contract and scope of the work. Overview of the dispute is noted the claimant had planned to achieve early completion. Claimant has foreseen to achieve the completion of the work within 18 months and to avail 6% bonus provided in the contract as per the works program submitted by the claimant. Accordingly, the immediately receipt of LOA 31st May, the claimant mobilized resources and commence the works upon the receipt of notice to commence the date. The extent of the claimant's preparedness and mobilization can be from the progress, this becomes really important. Progress achieved in the first 3 months of the contract, that is till October 2006, which stood at 8.4% of the contract value, despite the rains and the low value items being executed. Your Lordship the see, in contract, the entire contract, there are certain works which is of low value. In spite of being a low value, contractor was able to do it at 8.4% of the total work, total quantum of the work within 3 months of the commencement, such as the site clearance and earthwork. Delay in works according to the claimant. But according to the claimant, the progress of the works could not be sustained due to the various breaches and defaults of the respondent in fulfilling its basic fundamental obligations, which are essential and vital to enable the contractor to perform its obligations. But almost continuously, it has been provided up to 1.12. But in the note also, instead of reading the note, I am reading the whole thing. It is for convenience, it has been given before. And your Lordship perceive some of the such major defaults and breaches of the respondent have been provisions of the contract of set off below. But 42.2 says, the volume, failure to give possession of the site and access thereto. And then, this clause is at page 2671, the volume 8. It is not, it is volume 8. It has been not being noted. Volume 8, 2671. Just I will read reference 42.2. Page 2671. These are all the factors which the engineer will take into consideration for granting the extension. As a fact, extensions have been granted in this case. 42.2, your options received. If the contractor suffers the delay and an incurs cost from failure on the part of the employer to give the position in accordance with the terms of the clause 42.1, the engineer shall after due consultation with the employer and the contractor determine any extension of time to which the contract is entitled as clause 44, and the amount of such costs which shall be added to the contract. And of course, granting extension, additional cost has not been granted. But certainly, that doesn't deprive me from making a claim. 42.1, your Lordship perceive, save in so far the contract can describe. The extent of the portions of the site of which contract is to be given possession from time to time, in order in which such portions shall be made available to the contract subject to any requirement in the contract as to the order in which work shall be executed, the employer, with which employer's notice, engineer's notice to commence the work given to the contractor, possession of so much of site and such access as in accordance with the contract is to be provided by the engineer, but as may be required to enable the contractor to commence and proceed the execution of the works in accordance with the program referred to in clause 14. If any are otherwise in accordance with reasonable progress of the contractor shall by notice employer with a copy and make employer from time to time and with the contract of commission of such further as may be required to enable contractor to proceed with the execution works in due respect in accordance with such program or proposals as well. And the factors which could be taken by the engineer are 42.2, which has been referred in this. And then clause 6.4, delays in providing the drawings. But 2656 is the page, but if you make a note for it, that would be enough to save your Lordship's time. This clause 6.4 is there, the same volume 8 at 2656. Then this the clause 20.3, which is there at 2657. I would like to see 6.4 and 2656. Pagination of 6.31. A minute, brother.
Who's it spicy?
2650, I'm sorry. 2650. It looks like for the last letter looks like 6 or so. But these are very failure of inventory and all the circumstances we need to notice has been given to the contract in accordance with the engineer shall after due consultation inquire and contract. But these are all the factors whenever the delay and where murder which enables the contractor to seek extension and engineer murder grant extension which has been given in my piece and after the extension. Loss of damage to the employee, damage due to the employee's risk, delay in release of the payments, and whether the schedule of execution, schedule for execution further disrupted due to extensive changes and variations in the original scope of the contract. But these are all the clauses in it. 2650 is 6.4. 2657 is 2657 is 20.03. And then whether 2675 is this class 51, but we need not go into the clauses. The extent of the details of which the response was such that almost each and every representation promise and undertaking given by the respondent was found to be incorrect, false and wrong. Rendering all the basic assumptions and considerations made at the bid stage totally irrelevant and inapplicable to the new situation. Execution of the works as per the foreseen schedule was rendered impossible and the financial model of the contract was completely disrupted. The claimant also faced the severe disruption of class cash flow. But then, your lordship may see the page 207, 1.11. The claimant is further contingent, and these are all our contentions and their contentions or findings. Your lordship, the claimant is further contingent various events and circumstances behind it. But or else, I can avoid reading the contentions. I can come to the straight away. The findings for it to save the lordship's time. Okay, 213 page verified. Consideration 213 same one. From 2.13. This is correct how it has been considered. The total project comprises a construction of access control express way and overall to Hyderabad in pages to about beach. The project stretch and the reference is package 2 kilometers 11 to 24.38 phase 1 from Gachboli to Shamshara. Scope of the work is formation of the carriageway along with the construction structures across the waterways and tensions and railway projects. The employer has got Hyderabad Blue Card and been involved in the details of it. Team claimants submitted to duly filling up the rate prices against each of the items contained in the PO to offer a discount of 13.7% on the quoted price. Quoted price worked out to so after discount worked out to 295. And there are 3 milestones, correct? on account of the failure, on account of the failure to give the possession of site and access thereto, delays in providing drawings, instructions, and improvement of variation, and the original scope of the extra was totally 36. Delay events accepted by the respondent. Out of 43 delay events, the extension of time was given 7 times without any condition and up to 30th November 2020 for all the 3 milestones. However, the work was completed in milestone 1 on 14/12/2010, in milestone 2 on 4/2/2011, and milestone 3 on 30th April 2011, citing mainly non-availability of the site. Taking over certificate was issued. This is where I was saying something given with retrospective effect. 15/4 it was issued, but with retrospective effect from 24th May 2011. This this is available in volume 5, page 878. Volume 5, 878. This was issued on 15th April. With retrospective effect, it will be deemed to have been taken over on 24th May 2011. Like this. I'm to read from the impact, and I'm not used to it, but already about this. Taking over certificate. Yes. Page 878. Name of the work and agreement signed on CTA June. Issue the notice to proceed on 12th July 2006. Contract duration of schedule 12th January 2009. Contract price is so much. So much. Schedule date of completion is 12th January 2008. But extended date of completion is 30th November 2011. 2010. Then year next sheet 879 is not really eligible. The works of the milestone were substantially completed according to subclass 48.2 of the conditions of the contract and 24th May 2011. The defect liability period ends on 24th May 2013. Defect liability period would be from the date of taking over 2 years. So that's how this certificate itself. For 2013 is set to be issued, but with reference to the date. But that I don't think there is any dispute saying that there is admittedly it has been given in 2013, but with retrospective effect. There is no dispute because this time also steps for no. No, because this document as it shows issued on the 24th May 2000 at the bottom. No, I have said that's all. There is no dispute with regard to that. But the document itself speaks the other way. That is the reason why I am pointing out your option. There is no dispute about the fact that it was issued on 15th for 2013, but with effect from 24th May 2007. And then prolongation period return to the claimant is from 13/1/2009 to this originally no doubt it was taken up to December, but it has been reduced. I point out your options how my claim has been reduced. That appellate tribunal notes the condition number so and so the respondent is bound to provide the right of being this. And appropriate was a contract to specify this. Further, respondent is bound to hand over the site for all the junctions within 3 months. 3 months from the LO, it is observed that admittedly this has also not been handed over by the respondent. As per clause 41.1, the contractor is required to commence the work as soon as reasonably possible in the time stipulated in appendix to the tender after the interval. Appendix to bid on page number 29 of the contract provides time for commencement of the work under clause 41.7 days. The total time limit for completing the work scheduled completion is 30 months, wherein the milestone number 1 that is to be completed within 8 months. Milestone 2 so and so so. Then your lordship to say line about 6 correct to save your lordship's time. From the collective reading of all these contractual stipulations, your lordship got it correct?
Page number?
Page number 215, line about 7. Page number 215, line number 7. Internal page 69. Running pages.
Yes.
Bottom is the pagination. Internal page 69. Lordship got it correct?
Yes.
From the collective reading of all these contractual stipulations and conditions, it transpires that the respondent is bound to hand over the entire site, that is right of way and bridges with full possession and access to the site between 11 kilometers to 24.30 within 7 days of MOA, except for the junction. There are 3 months at the commencement of all junctions, so that the claimant can proceed to the work as per the program so as to achieve its completion within the scheduled time of completion for each milestone and whole of the work including the service work. As seen from the paragraph 3.1, it is clear the respondent is required and so to not only hand over the provisional site, but also to provide the permission and access to the site in 3 months after the commencement of the work so as to allow the claimant to 30 months MOA. The claimant has averred that it has not been handed over uninterrupted possession of the soil system. So, due to which completion of soil system, limit of 30 months in completion. In this regard, the claimant has rightly relied upon monthly progress report and other correspondence substantiating its plea regarding non-availability of the site, hindrances which persisted till the date of substantial completion and taking over. The arbitral tribunal has perused the extension time applications and the reasons for the delay. It is seen that the claimant has represented that it was prevented from executing the work due to reasons beyond its control and responsibility and short extension of time for completion of the work from time to time. Extension of time applications 1 to 8 were filed by the couple claimant are collectively filed as so and so from so and so pages to so and so. Time for determination by the engineer are filed at so and so. And the summary of extension of time applications and engineer determination of extension of time is exposed in the 2 CD volume 6 at so and so. The claimant had sought extension of time. We have applications for 43 delay events, which are enumerated in annexure 1 to the submission. The delay events into following categories. Current categories have also been discussed. I think not. This is only for the purpose of pointing out, but entire thing has been considered, including the report that correspondence between the parties, and then coming to a minute at 2.19, 1.27, internal page 73. 1.27, page 73. We note that the respondent has contended that the engineer had not approved the program. In this regard, we have produced the records and findings. Claimant has submitted the program which was returned by the engineer for incorporation of the comments resubmitted by the claimant and found in order by the engineer. Therefore, para 10.2.2 of this submission. No objection to the program was raised by the respondent after March 2007. Got it for it? One objection has also been page 73, 1.27. But subject to correction, but my friend is also here. Most of my friends' argument orally and written submission, which have been here, are like bullet points or whatever it is. Submission is that the arbitral tribunal findings are forward. But my main submission is going to be read after bringing to your lordship's notice the case law. perversity is no more a ground which can be raised for some arguing against the international commercial arbitrations, because that has been made clear by the judgments, including the judgment which have been cited by my friend. I will explain that I have taken through the judgments of the Honorable Supreme Court. But what has happened after 2016, 1996 Act coming into force, but generally keeping aside the case, facts of the case. After 1996, the various judgments have increased the scope of interference under Section 34. Then this has been curtailed by way of amendment in 2016. Curtailing so far as interference 34 is concerned, no doubt even from the earlier, the judgments say it is not an appellate forum for looking into entire evidence and screening the entire evidence, coming to a different conclusion is not permissible. But what could be looked into in grounds which are indicated in 34. But within the words which have been incorporated in the provisions, expansion has been made by the judgment law, which has been again removed by the basis of amendment to the Act. After amending specifically 34(2) has been made, saying that which is confined to only domestic arbitral award, that is an arbitral award arising out of the arbitrations other than international commercial arbitration may also be set aside by the court if the court finds that the award is vitiated by patent illegality. But perversity will fall under patent illegality. So that ground is no more available so far as the international commercial arbitrations are concerned. And this has been also dealt with subsequent to the amendment also their lordships have held, saying that perversity is no more a ground for setting aside the arbitral award so far as international commercial arbitrations are concerned, because perversity will make the award patently illegal. That ground is only available for the domestic commercial arbitration, but not international. So that's how looking into the judgments which have been cited, in addition to that, I cite few more judgments of the Supreme Court which clearly lays down the principle, saying that 34 application is not like an appeal where your office will look into the entire evidence, but I'm taking pains to look showing to your lordship the findings, saying that whatever record is there, this cannot be said to be arbitral tribunal without giving any reasons for it, awarding the compensation whichever prolongation cost or whatever has been awarded to be, has not been just awarded just like that without looking into, after having convinced with regards to the prolongation and the responsibility and the delays are attributable to the applicant before lordship, this has been done. And the point which has been argued by them has been answered at 1.27. Your lordship proceed. We note that the respondent has contended that the engineer has not approved the program. In this regard, we have perused the records. Claimant has submitted a program which was returned to the engineer for incorporation of the comments, resubmitted to the claimant, and found in order by the engineer. Refer to para 10.2.2 of this submission. No objection to the program was raised by the respondent after March 2007. We also note that the respondent has contended the claimant is obliged to complete the works whenever and wherever the site is handed over. This is what is being argued. Wherever the site is, because it is correct, it is not vertical, it is horizontal. The contract document clearly provides 3 milestones to be completed in the contract with specific date and defined scope of works to be executed, and each milestone is given. Contractor will be entitled to the extension of time for achieving the milestone. The overall completion of works based on the ground for extension of time mentioned in the contract. The fact that the respondent failed to hand over the site for each of the milestones is recorded by the engineer in several letters and recommendations for extension of time, as mentioned supra. Therefore, in our view, claimant is entitled to extension of time for completion of each milestone. Engineer recorded the recommendation on 5th January 2011. But the contractor's entitlement of extension for completion of each milestone will now extended concurrently 30th November 2010. We find no basis in contract conditions in support of the content respondent. There should be sub milestones within the milestones prescribed in the contract. In our view, contractor is obliged to achieve the completion of the work for each milestone within the available time for completion as per the clause 43 of the GCC. The respondent has not pointed out any requirement in contract to complete any part of the work in the milestone at any particular date. As such, the contents of the respondent in this regard are rejected. But saying that the areas where we have given you have delayed that execution, that cannot be taken because each milestone that has completed. Because of the delay is attributable to you because each milestone you are not able to hand over the sites according to the program which has been made part of the bid document. The respondent has contended that so-and-so program has not been used to demonstrate the delay on the part of the claimant submitted. Contract does not stipulate any specific procedure to be adopted for establishing the delays and consequent additional costs arising from the same. Claimant had submitted the extension of the time applications and interim extension of time documentation, and approval has been granted by the respondent up to 30th November. The reasons for the delay execution of the works up to this date have been recorded in various applications for interim extension of time. The approvals granted also record the reasons for the delay. It will be noted that failure of the respondent to hand over the site and delay in issuance of the drawings continue to affect the progress of the work since commencement of the work. Here is other reasons, however, overlapping with these governing details. However, from November 2010 onward, failure to hand over the site and delay in issuance of the drawings by the respondent continue to be governing reasons for the delay. After November 2010, balance of work fronts were isolated and spread at a different locations. Therefore, the claimant had to be in readiness to execute the work whenever and wherever the fronts were made available. In the absence of any timelines for handing over balance work front programs was not possible to be prepared. The works were executed as and when wherever the fronts were made available. The fact that the respondent could not hand over the parts of the site even until the expiry of the defect liability period is confirmed by the engineer at the time of granting defect liability certificate, and respondent has decided to exclude such parts from the scope of the contract. Your Lordship has seen that. Certain portions were excluded from the scope of the work because they could not hand over even by the defect liability period, which is 2 years from the date of taking over. The respondent is contended. Claimant is responsible for securing the permission of the removal of the utilities and removal of the trees, encroachment, obstruction. Respondent laid upon clauses to ensure. And but the contention is, but if some utilities were there, public utilities are, it is the responsibility of the applicants. But I cannot do anything except cooperating with them. That they said it is my responsibility, which has also been taken note of and answered your Lordship received. The respondent is contended the claimant is responsible for securing permission for removal of utilities, removal of trees, encroachment, obstruction. The respondent relied upon clauses to contract. In this regard, we note that clause 1.3.1 is in reference to site clearance, removal of trees and furniture. It is noted, and then at 2.23, I need not read the entire thing. In Roman 4D, that your Lordship will be permission to be taken from the respective authorities for removal of your Lordship got it page 74, 77, it is on page. The permission to be taken from respective authorities for removal of utilities and trees will be obtained by the respondent. Claimant's responsibility in this regard is confined only to coordinate with utility owner and authority. But you can't put the burden on me, Malad, saying that I should have taken it. The permission that has to be obtained by them. Removing the utilities, those are existing Malad in this stretch of land, Malad, where it's subject to the contract. These activities to be performed as part of coordinate are also specified in 1.3.2. The above provision further elaborated in clause 72. And then this particular aspect, but if you look at along with at the same time at 29, internal page 83. The fact of your Lordship's particular at 83 bottom, 3 lines. The fact of unavailable to site for any of the milestones is agreed and admitted by the engineer in letter dated 27/7/2011. Your Lordship must see when the contract was commenced in 2006. But engineer's letter dated 27/7/2011. which has been marked as Exhibit C30. Similarly, it is seen from Exhibit C40. And the work of shifting the applicability is also suffered due to approvals from the authorities and engineer, revision of scope, etc. to July 2007. But they were supposed to give the site permit without any hindrance within 7 days. And in the junctions, as your lordship has seen, within 3 months. But this has gone up to July 2007. From the above, we are fairly and reasonably conclude that there is a clear delay on the part of the respondent in handing over hindrance-free possession and access to the site. We also conclude that no default can be found on the part of the claimant in discharging its obligations with regard to the removal of encroachments and cutting of trees, shifting of utilities, etc. Cutting of trees is wrongly typed as the trees. From Exhibit C41, 42, 43, and 44, it is clear that there has been a delay in issuing the drawings and prevention of access to the site. It should be access to the site for execution of the road over bridge of ROB work. The perusal of Exhibit C44 amply demonstrate delay in providing drawings, revision of drawings and instructions given by the engineer. It is noted that the issuance of drawing itself was delayed up to June 2007, causing a delay of 300 days. And noted work commenced in 2006. But even in June 2007, they have given some drawings, which is 300 days after. It is seen from the Exhibit C66, the delay in conveying, the approval resulted in delay up to April 2007, nearly 250 days. The case of Foxton, but arbitral tribunal has produced exhibit which shows frequent changes in the design, alignment, revision of the plan, change in the scheme, and various other infrastructure, resulting in delay of work, which is solely attributable to the delay. This point is contended that the prolongation allegedly attributed to the respondent issue of the respondent is contained. It should be this is the paragraph. The claimant has contained a prolongation allegedly attributed to the respondent. Not proved by the claimant, right? It can't be by both respondents. Respondent has contained prolongation allegedly yes, correct. Respondent has contained prolongation allegedly attributed to the respondent. It's not proved by the claimant. By dragging of critical activity on critical path. However, the arbitral tribunal does not find substance in this content. Respondent has not pointed out any relevant contractual provision to substantiate the same. Arbitral tribunal has perused the delay mapping, which I was pointing out to delay mapping. This delay mapping is also there. Consideration of delay mapping is also there, if I remember right. At page 212, in any case, at the conclusion, it is there at 230 page. An impacted program filed by the claimant and is convinced with the claimant's way of representing the delays as per the usage in the trade to prove that the delay is not attributable to the claimant but to the respondent. The arbitral tribunal therefore relies on the engineer's clear recommendation to explain from time for completion from time to time of various delays caused by the respondent in giving unlimited permission and land to the claimant and proceed with the work as per the claimant's plan. It is noted to the claimant to prepare the program as per the clause 14 of the contract during consultations with the engineer and submitted to approval from the record placed before the arbitral tribunal. We see that the engineer did not refer it back to the claimant with further remarks or after its approval. Neither the parties put any document to show why engineer did not communicate it properly, which he was duly bound to integrate. If he was satisfied with the class 14 program, therefore, in the absence of any further remarks or reasons for non-approval, which we will have to put to payment, while the respondent to contradict the claimant's contention, the arbitral tribunal decides to rely upon the work program by the claimant, which is used as an approval, such as work program class 14 of the engineer's recommendation for remote for non-imposition of LDT and taking over facility on 15th of 2003. The backdated effect from 24/5/2011. The report of the DR dispute resolution board, not reach finality due to time constraints. Action to the respondent of occupying the road and putting it to use in numerous parts as and when they were completed, that from 14/11/2008, but they were using the portions of the road which has been laid by me. But they have given the certificate in 2013 with retrospective effect from 2011. And from November 2008 onwards, it has been put to use parts of the road which are completed. We fairly and reasonably conclude the respondent is clearly responsible for the delays, which is mainly due to the not handing over the uninterrupted possession and access to the site, delay in issuing drawings, delay in taking decisions, etc. Therefore, we conclude the respondent who committed the fundamental breach of contract and stipulations. That fact of EOT was granted claimant without information of great damage. It taking over is also established for the file. And therefore, we do not agree with the respondent's consent. Delay is attributable to the claimant. We find that there is a specific time bound provision in contract, as referred to for giving position and access, supply the drawing so that the claimant should complete the work. Each of the milestone and all of the work is scheduled in a quick program. Respondent has not pointed out any contract conditions, nor we could also find any such conditions in the contract and the week. Handing over the site's position and access to also related issues of the drawing in peaceful fashion, other than as specified in contract is permissible. As such, the respondent's contention is a delay in some part of the right of way, not handed over is not a sufficient condition. Delay the work and ROW handed over cannot be accepted. But the arbitral tribunal has produced the documents and comes to the conclusion of progress in the work. Three milestones, the whole of the work was grossly affected due to the failure of the respondent to hand over the site and unlimited position and access to the site. Delay on the part of the respondent issued drawing issue instructions. Now, at this stage itself, if I go to 236 minute top, or 235 bottom, that is page 89, internal page 89. You have a continuity, issue number 8 has been again considered. Then at page 89, last 2 lines, it's also seen from the record that no more work friends were available or any commitment. Timelines are given by the response. Regarding the release of remaining work friends, the claimant thus requested respondent on 18th May 2011 to permit the claimant for demobilization of resources, which was declined by the respondent as seen from the exhibit C65. But I wanted permit me to demobilize. They don't permit me. And you notice the recall that this was on 18th May 2011. They are giving the acceptance letter, handing over, taking over letter is valid with effect from April 2011. But it was issued in 2013. I was asking them for this they have not permitted me. Having not permitted me to demobilize my resources and utilize them elsewhere in my contracts, anywhere and elsewhere. And they cannot now come forward and say, no, I am not entitled. Your Lordship may now, after the para which I have read to your Lordship at 236, if I go to internal page 92, 238 is my running page, it doesn't tally internal page completely. Claimant is also brought to the notice of arbitral tribunal. The respondent refused the permission for demobilization of resources referring to the following event. But I have given various things. We have substantial completion of the work. 12 I have asked 18th July, August, according to the claimant. So therefore required to retain all the resources to seek and the funds for execution of the works were continued to be released on piecemeal basis. Claimant was thus compelled to retain resources at the site till 15th April 2013 for execution of the works for about value of rupees 30 crores during the period of May 2011 until April 2013. Details of the work done are being set out in the resolution. So that's how I've asked them to permit me to demobilize but they have refused. Respondent contentions have also been taken note for it, which begins at subparagraph F at the bottom of page 92. And these contentions have been answered. Your Lordship to see at page 95. Before I go to 95, 94 bottom. Respondent has contended that the defect liability period from 24th May 2011 to 26th December 2013 cannot be classified as host or prolongation for construction. I've already explained works on all the available funds were completed long before and works were put to its intended use progressively from 14th November 2008 onwards. 14th November, the respondent chose not to issue the taking over certificate for the works already put to its intended use in violation of the provisions of the contract. Contract was made to work in isolated locations in non-sequential manner to remain at the site by executing the works in peaceful basis wherever the work fronts were available. In 2011, the contractor's resources had become idle for a long period as the employer was not in a position to hand over the site to the schedule for handing over the site completely in balance. The matter records that during the period between 24th May 2011, the effective date of taking over and 15th April 2013, the date when taking over certificate was issued. Claimant has been executing the work, and the value of work executed during the same period is only value of 30 crores. The correspondence during the period 24th May to April, so claimant was executing work as per instructions involving his resources available. Nowhere from any of the correspondence exchanged with the parties until 15th April 2000. It appears that the period was under defect liability. Contractor was actually required to retain all the resources for executing the balance works until 15th April 2000, without any indication that 25th May 2011 will be the taking over certificate. But the certificate has been given with this prospective effect. So until then, the contractor was unaware of the fact that it will be given as a claimant's request for demobilization. Your Lordship will see top of page 96. The claimant's request for demobilization of resources was denied by the claimant. The contract was made to remain at the site with all its resources up to April 2013. Even as on that day, respondent was not in a position to hand over the whole of the remaining. However, on 15th April 2013, respondent issued taking over the backdated retrospective period from 25th May 2013. It is evident from the report. Respondent's failure to hand over the site and refusal to issue taking over certificate that compels claimant to remain at the site and incur the additional cost of therefore the respondent is liable to payment additional costs suffered from the claimant company when the taking over certificate is actually issued. Taking over certificate is once to issued at 15th April. Taking over certificate specifically mentioned parts of the work that could not be completed as displayed. Therefore, it is clear that taking over certificate of 24th June 2011 to be issued only because part of the work completed as at 25th May 2000. We see that the claimant has submitted interim payment application. Payment was required to remain at the site. Completion of the balance works till 15th April. In the date of issuance of the taking over, in view of the amount, funds contention deserves to be rejected. This fund has contended the claimant to the entitled payment claim has sustained, not compensation. The claimants argue claim is strictly in accordance with the contract definition of cost and from the contract. Cost means all expenditure properly incurred are to be incurred, whether or not the site, including the overheads and other charges properly allocated there too, but does not include any elements of profit. Therefore, it is passed as defined in the contract include all expenses, direct, indirect, on-site and off-site loaded, etc., except only the element of profit. We note that the claims submitted by the claimant have been accordingly prepaid. Contents of the response wanted to settle provisions of law. Usage of trade applicable to in this transaction and hence stands rejected. Respondent has referred to the overheads of road construction of 8% to 25%. I declare to the argument that the contentious response and not relevant to payment to the entire payment. An additional cost upon without any reference to the data. So that's how actual cost which has been incurred on account of not handing over the site of an element of profit cannot be taken according to the definition. But all this has been considered and to the extent where the claimant was entitled to this has been granted. We accept the claimant's argument for it. This is a 244, correct? Roman 7, page 98 in the page. We accept the claimant's argument in light of the cost referred to above oral evidence read by the claimant to prove the expenditure incurred. The respondent has sought the details of ownership document, depreciation, or income tax returns and profit and loss account. The claimant submitted. She had filed the copies of monthly progress reports and also minutes of meeting which recorded the resources of manpower and equipment deployed on a regular basis. The claimant has also produced audited books of account and profit and loss account. The actual vouchers and invoices of the equipment deployed and cost incurred and proofs such documents with an academic file test. The independent chartered accountant also now become on the claimant. The said witness has been cross-examined and the expenses supported by profit and loss account and created books of account, invoices, documents. Because arbitrary the examination of chartered accountant was cross-examined. We accept the claimant's contention. In the light of the document evidence placed before us and oral evidence reported argued, price adjustment beyond 13th November is not payable. But so far the price adjustment is concerned, but it is nothing but application of the formula. Because formula has been enunciated in the beginning. Variation of the components of the material which is being used. But it could be plus or minus. But in the cases where it goes up, the formula will be applied. But it will look like as though I am getting additional one. But it is the formula which has been accepted on the first day itself. But during the contract period also, but the values may go up and values may come down on the material which is being used. Whenever it comes down, value also gets down. So that is the reason that cannot be argued saying that beyond 30th November I am not entitled. As a fact, when they fail to give the site to me, they cannot say I am not entitled to the formula regard the material which is given. Cost of the material. It depends upon that formula. Last time also I explained this in much detail. But we will not proceed. And then they looked into valuation of the claims for quantifying the claims. After giving cogent reasons for coming to the conclusion that they are responsible for the delay and contract is entitled for the claim which is being made, amended claim, using the period, my claim, the time from up to which I am entitled. Earlier, no doubt it was up to December 2013, it has been corrected. As it has been corrected, but 7 months. 7 months period has been. Those corrections also I point out for the next week. A bit to convenience and convenience for friend and as well as this family for the value. Some people say 15, 16 years, any other date, subject to convenience before. Also to my high level for this coming case.
Can it be 20th now? Monday.
Any date beyond 22nd. 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 22nd.
in that case, when we did,
27th. 20th is Monday, again 27th would be Monday. Oh, holiday.
20th, I said 20.
No, you said 20, I said 27. But 27 seems to be holiday. So 28, 28. The Lord has said that the 20, beyond 22nd, I said 27. But really struggling so many pages.
Because can it be 15th of December?
So it will be too long a period. But not only me, but even your lordship, it will become difficult for us to pull it. Entire material because very voluminous record is there. Sometime in November itself, it will be, if it is concluded, it will be better, but otherwise, it will become difficult.
In that case, will it be 6th of December?
The moment
I have to leave what is would matter, but I come minutes and join there. 6th, I said 6th.
It's continuously for 2 days. Hopefully, but we know that should not be possible because I have only 2 days.
So I have to do that one. Continuous, once then in that case, we can have.
But may request for 5th and 6th for it.
There are no holidays in December.
No, 5th and 6th for it, it will be, if it is convenient for not.
If have a problem. If because by the next week wants dates.
Let me complete on 5th. Let my friend complete for it on 6th for it.
No, I want to hear you, sir. 6th is 5 minutes. And on that day, minutes we'll see.
7 is also, but if it is 7 is closed, but then it is a convenient.
Actually, I have organized one university conference for me, dates, 5 minutes.
It's fair 7th also, yeah.
That's good.
Mr. Rishik and Sankar,
Yes,
inform our court staff
Yes.
1 day in advance, so that I will have limited matters in the list. That is better because many.
First may have it on 6th, and then you will fix other.
Oh, what?
One
What
day.
is fallen from the bench is different, nothing. You go and me.
Okay.
So I'll give instructions to the section not to post many matters.
So many.
Next day.
Yes.
One, your Mr. Prakash Reddy, some personal reasons there was some delay. Your one education matter, actually it is here. Is there urgency? One.
Probably a current year.
Yes. Oh. Was
Where Mr. Tarun was on record.
matter, there is a delay from my side. Just wanted to inquire if from council on record.
So
Is there any urgency?
I tell Mr. Tarun that he was assisting
Due to some setbacks, I could not complete these matters and too many administrative assignments. Right, to complete it last week itself.
I informed Mr. Tarun that he did, but he didn't. Let's.
Only have you informed them? 13 and 14 items. Otherwise, I like two more. Mentioned matters will come tomorrow or day after.
Tomorrow it goes out of the list now.
Tomorrow.
Items 73.
Mentioned matters will come.